Good morning, everybody. Happy Tuesday, which feels like Monday, but it is actually Tuesday. Welcome to the Courtroom Files Live. I hope you all had a good holiday weekend. Undoubtedly, they partied in Miami-Dade. Let's see how bad it was and start with Judge Glazer.
Yes, Your Honor.
Next is Precious Jackson. Miss Jackson here?
Your Honor, can we take one at a time? We have a gentleman here for corrections.
Sure. Is it on this warrant calendar or something else?
Sure, Your Honor.
Next on the calendar will be Lavin Sarkanovic.
Oh, I'm sorry, Maldet Maladen Sarkanovic? Well, I don't know what I'm sorry, it's his new case. Where's the paperwork? Really? Oh, I'm so sorry. I'm going too fast here. There's so many new cases today. Next case is Maladen Sarkanovic. Good morning, sir. Sir, you have an arrest warrant. It is from Indiana. The warrant was issued on May 7th of 2025 for stalking. One count, it looks like five counts for one case and 6 counts in another for stalking. There is no bond on this arrest warrant, and I need you to tell me if you want to waive or contest extradition. Waiver's the quickest way out of this jail. Indiana would have up to 30 days to come and pick you up. If they don't pick you up within 30 days, you get released. The other choice you have is to contest extradition, which means you want to fight the warrant. You're not fighting the charges, just a piece of paper that says you're wanted in Indiana. Then a lawyer would be appointed for you. If you cannot afford one, your lawyer, actually, they're going to come pick you up 30 days after your Miami case is closed if you want to waive extradition. So whenever you close that misdemeanor out, you can be brought back here. They'd have 30 days to pick you up, or you can contest extradition, fight the warrant, and you'll be held here up to 90 days. So what do you want to do, waive or contest?
What happens in either case? I mean, when am I free to go?
You're not going to be free to go. You're going to Indiana one way or the other. If you waive, you'll go there quicker. If you want to contest, your lawyer can fight the warrant, but chances are it's you and you're going to go.
Okay, I'm gonna wait.
That's a smart choice. You get out of here quicker. Your Miami case is set tomorrow? Or
Yeah,
no?
but I don't. Can I just tell you something? That stalking case is for me trying to talk to my kid.
It doesn't, I know, but it's not me. They did it in Indiana. It's not me. I have no say over it. You got to talk to
Gotcha.
the judge in
But it's
Indiana.
illegal because the Hispanic gang has set all this up. That's criminals.
Yeah, I hear you.
I was trying to talk to my child. You might think I'm crazy. I'm not crazy, but all I wanted to do was talk to my kid.
So don't talk
Indiana by
about the
criminals.
charges. They can always
Okay.
get a copy of this and hold it against you. When's his local case set, corrections?
It's going later on, Your Honor,
Today or tomorrow?
today.
So what is it for?
Entering park after hours.
Okay, let them know you have this warrant in Indiana and not to tell them you have to resolve that case before you can be sent to Indiana. Maybe they'll dismiss it, okay? Let the judge there know you have the warrant from Indiana. Let's set it tomorrow to see if he closes it out. Reset 9/3.
Is it waiver, Your Honor?
He waived, yes, he did waive. Okay, have a nice day, sir. Next is Precious Jackson.
Present, Your Honor.
Hi, Miss Jackson. You were arrested on a warrant from Texas. The warrant was issued on March 19th of 2025. It says felony abandon endangered child. I don't know, with intent I don't know, it says INDV with intent return, 2 counts. So there's no bond on this warrant from Texas. I need you to tell me if you want to waive or contest extradition. Waiver is the quickest way out of this jail. Texas would have up to 30 days to pick you up. If they don't pick you up within 30 days, you get released. The other choice you have is to contest extradition, which means you want to fight the warrant. You're not fighting the charges, just a piece of paper that says you're wanted in Texas. A lawyer would then be appointed for you if you cannot afford one, and your lawyer will be able to challenge the legal sufficiency of a governor's warrant, but you'll be in our jail at least 90 days. So those are your, what do you want to do, waive or contest? I can't hear a thing.
I just wait. They have 30 days to come.
Up to 30 days. Texas is pretty quick. They usually come within 15 days. And she was on a cruise and lives there. You want to waive and get out of here quicker? It's what most people do.
Yes.
It's a smart choice. Waiver, no bond. Reset date will be September 17th to make sure she's picked up. Please make sure you sign the waiver paperwork at the jail. It just means you agree to be transported to Texas. Have a good day, ma'am. Now we have Jose Ravello Mendez. He's at Metro West 2. He needs a Spanish interpreter. Sir, good morning, sir. You have a local case pending here, an open felony. The next court date is September 8th.
Señor, tiene un caso pendiente de delito mayor, un caso local pendiente, es un caso, la próxima cita es el 8 de septiembre.
We're going to reset this case September 9th to see if you've closed out your Miami case. Have a nice day.
Vamos a fijar el caso para el 9 de septiembre para ver si ha cerrado el caso de Miami el 8 de septiembre. ¿Está bien? Ya
El
puede
problema
ser.
es que yo no sé qué caso está diciendo ya, porque el problema es que la policía aquí está haciendo lo que quiera últimamente ya. Porque yo ni me le mandé a la policía, ni nada de lo que están diciendo la policía, me están poniendo una felonía que eso no lo he visto yo ninguna vez y no entiendo nada.
¿Quiere
Que
que,
me busque que la policía...
¿Me dejas traducir para que ella te pueda entender?
Sí,
Okay, gracias. So yeah, I don't know what's going on because the problem is that the police is doing whatever they want, here, because I never even, I never called the police and none of the things that the police is saying is true. It's a felony that is, I've never ever seen that before.
Sir,
So,
that case isn't before this court. You need to talk to your public defender on that case.
señor, ese caso que usted está hablando no está ahora presente en este caso. Usted va a tener que hablar con el abogado que está presente. Ese caso no está presente aquí en esta corte. Tiene que hablar con el abogado de oficio. ¿Está bien?
All right. Reset September 9th to see what's going on with this felony.
Vamos a fijar entonces para el 9 de septiembre para ver lo que está pasando con el caso de delito mayor. ¿Está bien?
Have a nice day.
Que tenga buen día.
Next is
Ya
Frank
puede llamar al
Perez
carcelero.
Ayala Quash. Tedrick Lee. Mr. Lee here.
Ya puedes llamar al carcelero para salir de ahí.
Tedrick Lee is a transfer. He's a Quash.
He's a no entendí nada, pero bueno.
Juan Restano.
Here, Your Honor.
Restano, hey, sir. Good morning. Looks like they need an extension of time. They're requesting an extension of time from Texas to pick you up for 11 days. The 30th day is the 21st. They're not getting their 11 days.
You should be picking up at the 19th.
They're going to pick you up hopefully by the 19th. They need an extension of
But
time.
my due date was the 15th. I signed on the 15th. You can look at the
Let me
paper I
see.
signed.
I'm going to look at the paper. I always do.
All right, thank you.
He came in on the 15th. He had locals. He waived. The locals he bonded out on the 20th. On August 22nd, we wanted to see if his misdemeanor was closed. His locals were closed on August 22nd. When did he bond out, corrections?
On the 15th.
Your Honor, I have an 8/21, he closed his case. He came here on the 22nd, and he was set for report 9/8/25.
So did he post a bond on it as well?
He posted the bond, and after he posted the bond, then he took a withhold.
When did he post the bond? What day?
19.
On the 19th?
No, the 15th.
No, they're telling me the 19th. 1 minute.
He posted bond on the 19th, and then on the 21st, he took a withhold adjudication, and then on the 22nd, he came here in front of you, and he was set for report 9/8/25.
Okay, so if he posted the bond on the 19th, oh, it doesn't matter when he posted the bond because you were being held no bond here. It's when your case is closed. It was closed on the 22nd, so we have to go, and then you're brought here on 8. When did he close at 8/22, right?
He closed at 8/21, and then on 8/22, he came in front of you, and you set for report 9/8/25.
Yeah, it's from the 21st. So that's fine. They're gonna pick you up by the 19th, which is like the 30th day. I'm sorry about that. If you're still here I'll set it. When do you want me, when's the 19th, a weekday?
Right.
Let me set it the 19th? Yeah. Reset September 19th.
Thank you.
And if you're still here then, they should be picking you up by then and hopefully you'll be gone.
All right, thanks.
Thank you, sir.
Your Honor, may we recall page 7, Mark Duverson? He's here. He does wish to waive.
Okay, sure. Then I gotta do my in-state calendar while we're running behind. Mr. Duperson, what's going on? You want to waive extradition, get out of your court?
Yes. Say, I want to wait. Say it loud. Say it like you're speaking to somebody in the stadium.
Yeah, we can't hear you.
What should I do? What should I? That's my first time. I don't know.
Want to waive. I want to waive. That means the extradition, they only have 30 days to pick you up. Okay.
Yes.
But say it in a voice like these.
I want to waive.
I think they're working on this.
In 30 days, I'll release you. So we set 9/17. Please make sure you sign the waiver, people.
Yana, we can't hear you.
Oh, I'm doing all that talking. He can't even hear me. I'm so sorry. All right, Mr. Duverson,
Yes.
waiving's a smart choice because you get out of the jail quicker. The reset date here is September 17th to make sure you get picked up. We set it in 15 days. They have 30 days to come and pick you up. And if they don't pick you up within 30 days, I'll release you. Okay, sir?
Thank
Please sign the waiver paperwork at the jail. It just means you agree to go to Texas. And you should be able to get a bond, hopefully, once you get there. Have a nice day.
Thank you.
Thank you, sir. No, that's it for the warrants. Thank you, Miss John.
Have a good day, Jen.
Have a good day.
Bye.
Next case is the in-state warrants. Tasha Posse. Thank you.
So good morning once again, everybody. Welcome to the Courtroom Files Live. We'll continue to ride with Judge Glazer here for a little bit. Other courts are just starting to come online, and we'll get to them in a minute, but we'll stay here for now.
I will appoint the public defender's office for you. Unfortunately, there is no bond, and you're going to have to wait up to 15 days for Broward County to pick you up. The reset date here is September 17th to make sure you are transported. They usually come once a week. You shouldn't have to wait that long. Have a good day.
Okay, thank you.
Next we have is Rachel Bem.
She's coming, Your Honor.
Good morning.
Stand here, look at the judge.
Next, all right, hello, Miss Bem. You have an arrest warrant from Broward County. The warrant was issued August 30th of 2025. It says no lodging on city property, so $150 bond. I will appoint the public defender's office for you. If you can post a $150 bond, you can get out of jail. If you don't have any money for a bond, you will have to wait up to 15 days for Broward County to pick you up. The reset date here is September 17th to make sure you either posted a bond or were transported to Broward. Have a nice day.
Hold on, I can ask you a question.
Yes, of course.
Would there any way I could possibly maybe get like what is it? It's like pretrial probation or something for this?
So I can't do that. You got to ask the judge in Broward County. You got to see it's a different county. Yeah.
Could can I get a lower bond for here?
I can't adjust their bond. That's up to Broward, but $150 is pretty low. It's not a lot. It's not low if you don't have any money, but it's compared to some of the bonds they set, that's a pretty low bond. Anyway,
Yeah,
good luck to you.
it is pretty low. It's difficult using the phone sometimes.
No, I know. I'm sorry, ma'am. But you know what? They usually come once a week for Broward, and it's the beginning of the week. So hopefully you'll go see a judge sometime this week, and then hopefully that judge will just release you. Okay?
Yeah, because I don't even understand the charge really.
Well, you're not allowed to lodge on city property. That's why.
Would I like sleep somewhere?
Yeah.
I don't even go to Broward like that. But okay. Have a good evening. Thank you.
Have a good one. Next is Stephen Foster at Metro West 4. Good morning, sir. You have a warrant from Orange County. It was issued May 12th of 2016. The charge is domestic battery, failure to appear for a battery, and it says no bond. I will appoint the public defender's office for you. Orange County has up to 15 days to pick you up. The reset date here is September 17th to make sure you are transported there. And the public defender's office will answer, you can call them with any questions, okay?
Yes.
Have a nice day. Next is Alistair Martin. Good morning, Mr. Martin. Page
Morning.
Metro West 5. You have an arrest warrant from Broward County that was issued on March 13th of 2024. It's a writ of arrest and a commitment for child support. So your cash purge is $1,064. I will appoint the public defender's office for you. If you are able to post a $1,064 cash purge, you can get out of jail, pay it here in Miami. If you don't have any money for that, any cash to pay that, you're gonna have to wait up to 15 days for Broward County to pick you up. The reset date here is September 17th to make sure you were either transported or posted that cash purge, all right?
Okay, may I say something? On
Yes, of
Friday,
course.
I got a ROR from here and I was told that I was told by the public defender that Monday I'd be picked up, but then I was told on the Zoom court yesterday, on Friday, that it would be today. So where does
By
the
whom?
15?
The
Huh?
15 days starts today. 15 days starts today, but Broward usually comes once a week. You shouldn't have to wait that long. You'll probably go sometime this week. Okay?
Okay.
Have a nice day, sir. Good luck to you.
All right.
Rainiel Perez is next. Is he there?
Coming up, Your Honor.
Is this Mr. Rainiel Perez? Does he speak English?
Yes, Your Honor. Yes, Your Honor.
Sir, good morning. You have an arrest warrant from Orange County. Looks like you owe child support. It's a writ, it's actually a writ of bodily attachment that was issued June 18th of 2025 for child support. It's a $3,000 cash purge. I will appoint the public defender's office for you. If you're able to post a $3,000 cash purge, do
I
so.
already paid that, Your Honor. On June.
Cash?
Cash.
Corrections, did he pay it? If he did, why is he here?
I don't have anything on that, Your Honor.
They don't have any information you paid it. Go
Yeah,
follow up.
they're still on the system, and I got the receiving home that I paid that in June.
No. This was just issued June 18th of 2025 that you owe it. So public defender's office is appointed. You can call them with any questions. The reset date is September 17th to make sure you either paid your cash purge of $3,000 or were
I already
transported.
paid that, Your Honor.
You gotta talk to the judge in Broward, in Orange County, because right now it shows you didn't pay it.
Yeah,
I
because
know.
they didn't take it out from the system properly. Because 2 months ago I paid $3,000. I don't have another $3,000 2 months after that.
I know. You have a lawyer at the public defender. They can look into it. Is there anybody that can
I didn't
send
got
them?
no.
Maybe Mr.
Maybe.
Wilson can reach out, but did you pay it to the registry or to the mom?
No, I paid here
In
in Miami.
Who did you pay?
Here on the.
Did you get a receipt?
Here, you paid in the jail?
Yeah.
You paid in the jail?
Yeah, my wife came and paid on the machine $3,000. They give you the receipt to her, and they give another receipt to me when they release me.
Could she get a copy of that receipt to send to the public defender's office?
I guess I know, but we don't got no communication where we are right now.
Maybe Mr. Wilson can take her number. They can reach out to her. Anything's possible.
I mean, why are they still on the system when I paid $3,000 2 months ago?
I don't know. So you want me to reset it for the afternoon, or you want to just bring it back, Mr. Wilson? You can even bring it back in the morning.
Yeah, if you want to reset it to tomorrow morning, Your Honor,
Yeah.
I'll reach out to his wife, see if they have any.
Okay, I don't want to delay him if he's getting picked up. Why don't I set it in the afternoon today?
Oh, yes, Your Honor.
I'll reset it if she can get a receipt, no problem.
But they don't show up on the system either way.
It should.
Pay.
It should. We'll find out.
No, he's saying.
All right.
See,
Next is Scott Murthel. Mr. Murthel there.
is it Sophia? Is that your wife?
Yeah, that's my wife.
All right, I'll call you. You said she has the receipt?
I guess she got the receipt.
You just said she has the receipt.
All right, we'll keep an eye on Miami-Dade because they're going to be busy there today, I think. Let's head to Texas though. Judge West. Normally the first time of the week we see her parade of fashion, but it's a Tuesday, so it's a parade of orange.
Good morning, sir. Are you Donovan Spencer? Good morning, Mr. Smith. Give me just a second. And Mr. Rojas, will your client waive the formal reading of the motion?
He will, Your Honor.
Well, it's coming. Hopefully. Did they? Good morning. Good morning. Okay. Mr. Spencer, in cause number 24, DCCR 0261, I have a motion to revoke your community supervision. Shows that you were placed on probation July 17th of 2024 for assault on a peace officer, and that was a 10-year term in prison that was probated for 10 years. Is that correct? And it alleges that you violated your probation. Count 1 alleges that you failed to report as directed July 8th of 2025, and is that true or not true? True. Count 2 alleges that you failed to complete the mental health evaluation and follow all of the recommendations, and is that true or not true? True. Count 3 alleges that you failed to successfully complete the SafeP program. Is that true or not true? True. And then count 4 alleges that you failed to submit to an alcohol or drug screening July 1st of 2025, and is that true or not true? Did you enter your pleas of true to counts 1 through 4 freely and voluntarily? And did you plead true to those counts because they're actually true? I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? And do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is to cap your punishment at 6 years. And so what that means is that we will reset your case. I'll get an updated pre-sentence report. We'll come back and see. I'll get any evidence that's presented, and then I'll decide your sentence. And as long as I do not give you more than 6 years in prison, you can't appeal that. You understand? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Spencer is not competent?
Okay.
All right, sir, I'm going to find that you entered your plea of guilty your pleas of true to counts 1, 2, 3, and 4 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, but I'm not going to do that today. I'm going to reset your case for sentencing. Anything that you think is important for me to know, get that information to Mr. Rojas, and he will present it to me on your behalf when we come back. All right, we'll see you back at sentencing.
Thank you, Judge.
Thank you. And we reset Wilkerson. Ms. Perazo, you have Jose Lopez Pamias.
I don't have an interpreter. Could not be here today. Because I didn't find out until this morning that he wasn't going to be able to make it.
Okay, we have to do something. Okay, I'll hold it while we get an interpreter. You have Trayvon Alexander. Good morning. Let's see if we can get Ms. Cepeda on the phone, but maybe just for a minute if you don't mind. Thank you, Mr. Rojas.
Thank you, Barbara, for gifting the membership. Very kind of you. Always appreciated. Thank you so much for your support.
And Charlie could do it for the pre-trial, didn't he? think about that.
She's coming back to.
Okay, we're good, Mr. Rojas. Thank you, sir. Good morning. Are you Traven Alexander? And this is 25 DCCR 0831. Mr. Alexander is charged with murder. And Ms. Perazzo, what is the announcement?
Your Honor, we have not quite completed reviewing all of the discovery, so if I could just have
Sure.
additional
This
time
is,
to review.
yeah, just indicted, looks like 40 days ago. Okay, and so, Mr. Alexander, what I'm going to do is reset your case about 30 days or so to give Ms. Perazzo some more time to make sure she has all the discovery from the district attorney's office. She will be out there to go over all of that with you before the next court date, everything that she has, and then we'll see if we can get an announcement at that point, okay? All right, you can go back with the bailiff.
Is that okay? Okay.
Mr. LeBlanc, you have Lenny Leday. Okay, good morning. That's right. Okay. Yeah. All right, so you're Lenny Leday?
Yes, ma'am.
And this is 23 DCCR 0783, and Mr. Leday is charged with sexual assault. There was a withdrawal. We've gone through a couple of attorneys. Mr. LeBlanc has been appointed, and Mr. LeBlanc, what is the announcement?
Judge, as far as I understand, his plea is still the same. We're getting ready for trial. I've gotten with his other attorney and got the information from him.
Okay.
And so it's.
No change in any offers or anything like that. All right, so Mr. Leday, what I'll do is move your case back onto the trial docket, and Mr. LeBlanc will continue getting ready for trial, and we'll get it tried as quickly as we can. All right, you go back with the bailiff. Thank you, sir. Ms. Holmes, you have Jordan Thomas.
Yes, ma'am, you can hold them.
We've gotten an offer. He'd like a chance to talk with his family. It is a extensive time offer.
Okay.
And so we were asking if we can get, even if it's a short recess, so he can have time to discuss with his family.
Okay. We'll just a couple of weeks?
Yeah, that's fine.
Okay, we'll reset him 2 weeks, and we'll need an announcement
Yes,
for sure
ma'am.
at that time. Thanks. And then you have Sharita Washington?
Yes, we're ready on her.
Did you do
It's
paper?
gonna be relapse safety. I don't know if we needed to do paperwork on it. Do we need to do it?
I don't know. Is there? Let me look at it real quick, and then we'll. Good morning, you're Sharita Washington?
Yes, ma'am.
Give me just a second. Good morning. Good morning, Ms. Malfino. Good, thank you. Let's see. Okay. So, she was ordered a safe P already. Does she go and,
She was unsuccessfully discharged from the aftercare, the Melton. She left the Melton Center.
so the agreement is to go back to for relapse? Does it need to be is there a special needs relapse?
Yeah,
Okay.
special needs. She's got a lot of.
Sure. Ms. Washington, the best you can, raise your right hand for me, please. Do you swear or affirm the testimony you give in this hearing will be the truth, the whole truth, and nothing but the truth? All All right, and will she waive the formal reading of the motion?
Yes, Your Honor.
Ms. Washington, in cause number 23, DCCR 1036, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation September 10th of 2024 for harassment of a public servant, and that was a 2-year deferred probation. Is that correct?
Yes, ma'am.
It alleges you violated your probation. Count 1 alleges that you failed to report as directed to the probation department June 2nd of 2025. And is that true or not true?
True.
Count 2 alleges that you failed to enroll in services at the Spindletop Center. Is that true or not true?
I didn't tell me nothing about the inmates and more services, but I can do it though.
Okay, so do not true for 2. Count 3 alleges that you're behind in your court assessed fees.
Yes,
Is
ma'am.
that true or not
Yes,
true?
ma'am. True.
True. And then count 4 alleges that you failed to successfully complete the SafeP program, including the aftercare. Is that true?
Yes, that's true.
Okay. Did you enter your plea of true to counts 1, 3, and 4 freely and voluntarily?
Yes, ma'am.
And because those counts are actually true.
Yes, ma'am.
So it's my understanding, Ms. Washington, that probation feels like you still deserve a chance and that you have the ability to take advantage of some services and be successful. I want to make sure you understand from my standpoint, I have no doubt that they have let you know about everything, okay? From the very beginning with regard to SafeP, with regard to any special services through Spindletop. If you don't take advantage of this opportunity this time, and you're back in here because you didn't go and receive services or you don't successfully complete the relapse program at SafeP, we're not going to be talking about keeping you on probation. You understand? You could go to prison for 10 years today for violating your probation. It's that serious. So you need to make sure you take advantage of everything they have to offer you, okay? All right, so
Would the court consider maybe extending?
I'm gonna have to, yeah, for sure. It's gonna be extended, I would think, by at least 2 years. So, I'm gonna make your probation go longer because you gotta go back through SafeP now, so it's gonna take longer. So you're gonna have to prove that you can be successful, so I'm going to extend your probation.
Okay.
Hold on just a second. So here's another thing that's very important. Your behavior in the jail is something that I find out about. Okay, I get incident reports,
Yeah.
and hang on, and it explains every time you get an incident report, every time you're calling a correctional officer the B word, every time, hang
I wanna
on.
know my benefits.
Well, and I understand that there might be some issues, okay? But I want to make sure that you do the best you can
Yes, ma'am.
to follow all of the rules and not be disrespectful
Okay.
to anybody that's in there just doing their job and trying to help, right?
Yes.
They're just going to work every day,
Yeah.
okay? They don't deserve to be treated that way. That includes when you're in SafeP. Because if you get to SafeP and you're on your medicines and everything's correct and you're acting like this, then you're going to end up getting revoked before you ever get out. Does that make sense?
Yes, ma'am.
Okay. So I'm going to find that you entered your plea of true to counts 1, 3, and 4 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. I'm going to follow this agreement and I'm going to extend your probation for 2 years. And I'm going to order that you enter and successfully complete the Special Needs Relapse Safety Program. Obviously, when you get out, you will be required to go to the Spindletop Center, be evaluated, follow through with any recommendations they have of treatment or medication or whatever it is. And all of that is so that you are successful, okay?
Okay.
All right, good luck to you, ma'am. You can go back with the bailiff.
Have a blessed day.
Thank you, ma'am. You too. And then, Ms. Holmes, you have Jamal Caddy?
Yes, Your Honor. They're gonna do a bailiff's call on this one.
Okay.
Jamil.
Jamil.
Caddy.
Okay.
While we wait for that next contestant, Barbara just asked in the chat, what are the stats on making it through probation, like 9%? It's not that simple, Barbara. It has to do with many factors. The length of the probation, the age of the defendant are all factors, but the younger they are and or the longer it goes, the less of a chance of making it through.
To do a bailiff's call.
Yeah, yes, Judge. Cherie Drake.
Cherie Drake.
No response, Your Honor.
Judge, just for the record in this case, Cherie Drake was sent a subpoena and a letter separately. She received both. She did call our office, said she did not want to come, said she doesn't care what happens to the defendant, and that she had other things going. So with that, state will file a motion to dismiss.
All right, so I'll sign that. So, Mr. Caddy, I'm not sure what the relationship is going forward with Ms. Drake, but I'm looking at the probable cause affidavit in your case, and it's not pretty what the allegations are that you did to her. And if you get out, my suggestion is you go do your own thing without her, and you learn to keep your hands to yourself when it comes to whoever you're dated, okay? Go back with the bailiff.
We'll keep an eye on Judge West and come back to her at some point, but there's a rare Judge Bryant sighting. So let's see what she's got going on this morning. I have no idea, but, you know, we see her like once every 6 to 8 weeks. So let's see what's up.
Give me 1 second. All right, today is the day set for the pretrial conference. It is at least the second scheduling of the pretrial conference. The complaining witness was required to appear. They have failed to appear. People have no explanation for the failure. They are unable to proceed. The court is going to grant defense counsel's motion, and the matter is dismissed without prejudice. Ma'am, we will mail you a copy of the order of dismissal for your records.
Okay, thank you.
Is there anything further for the record?
No, by the people. Thank you, Your Honor.
Nothing further. Thank you, Your Honor.
All right, ma'am, then you're all set. Have a great day and stay safe.
You too. Thank you.
You're welcome. Miss Hall, I have Miss Reader's name highlighted, but did you all speak to Miss Reader?
I did not speak to Miss Reader.
All right, and then do we know who Watkins is? Mr. Hill, do you know who Watkins is?
No, Your Honor. I don't see him listed. Could have been a reappearance, but that name's not on my docket.
Miss Reader, please accept to join the breakout room. To the jail, who do I have?
Oh, I'm sorry, Ali Elayan.
Mr. Flanagan, do I have a tether violation?
No, Your Honor.
Is the deputy in the room, please?
Yes, Your Honor. This is for review.
Not on my docket. Let's see.
Good morning, Your Honor.
Good morning. What's the name again?
Ali Alayan.
Oh, that's not for today. Wasn't this was on my docket some other time, Mr. Flanagan? No. Hold on,
I'm
please.
sorry.
The last name
Judge.
is Ilayan, correct?
Ilayan, correct.
Ilayan. Mr. Flanagan, can you look that up?
Yes, Your Honor, I see him. He's was transferred to Judge Holmes Specialty Court, and the case is actually in warrant status.
Oh, he's supposed to be with Judge Holmes, and he's in warrant status. You could log him on to Judge Holmes. He's not on my docket.
Roger that. Sorry
All
about
right.
the mistake, Your Honor.
That's okay. That's okay. Mr. Ogletree?
Yes, Your Honor.
I'm ready. This is case number 254569902. The people of the state of Michigan versus Terrence Gerald Mathis. Defendant is charged with 1 count of assault or assault and battery. Today is the date set for pretrial conference. Appearances, please.
Morning, Your Honor. Alex Hill on behalf of the people.
Good morning, Aaron Ogletree on behalf of Mr. Mathis. P number 69167. Can you state your name, Mr. Mathis?
Yes, Terrence Mathis,
What's your middle name, sir?
Gerald.
All right. Today is the day set for pretrial conference. Mr. Ogletree, how do you wish to proceed?
Yes. I don't know if the complaining witness has not shown or not. If the complaining witness hasn't, we respectfully request a dismissal.
All right. Hold on right there. Let me ask this question, Mr. Flanagan. Well, Mr. Hill, let me give you an opportunity first. Go ahead.
Your Honor, the complainant, Elena Caldwell, is not present today. I do have notes in the file that indicate this defendant 2, did have an intimate relationship with her at some point in the past. So I don't know if the court would entertain splitting one to Garrett, but further, we would just ask for an adjourned pretrial to locate and notify. A person did contact our office and just updated their mailing address. So we respectfully want one more time. She contacted us on the 28th of August.
Well, let me ask this question. Well, so now to Mr. Flanagan. Mr. Flanagan, defendant number 1, what is the status?
Your Honor, Ms. Reeder is defendant number 1.
Oh, she's on the docket right now today.
Yes.
Okay, so then hold on. Oh, I wasn't aware. Okay, Ms. Hall is talking to Ms. Reeder right now. So a long time ago, I don't remember when they changed this. At least it's been before COVID. I know that much. The co-defendants' cases used to be listed together. And so now you got to try to figure it out. So Ms. Reeder is on the docket. I wasn't aware of that. Number 2, and here she is. So let me get there's Ms. Hall. That's great. Ms. Hall, come on. I wasn't aware that Ms. Reeder was the defendant number 1. So then I'm also calling case number 254699001, the people versus Shafan Lastar Reeder. Defendant is charged with assault or assault and battery. Today is the day set for pretrial conference. Ms. Hall, your appearance, please.
Verkedia Hall on behalf of Shafan Reeder. Ma'am, may you state your name?
Shafan Reeder.
Your middle name, please.
Shafan Lastar Reeder.
All right. So, Ms. Hall, today is the day set for pretrial conference. How do you wish to proceed?
Your Honor, we are requesting a dismissal due to the complaining witness's failure to appear.
All right, Mr. Hill, restate your response to Mr. Ogletree's motion with respect to Ms. Hall.
Your Honor, respectfully, we are asking for an adjourned pretrial to locate and notify Ms. Elaine Caldwell. We believe there's good cause because she has been in contact with our office as recently as August 28th. She did so to update her address. She indicates she received notice for the prior court hearing the day after the actual pretrial, which I believe was in July. Furthermore,
well, that's confusing me. And so let me ask this question. Are there any more defendants? Is it just defendants 1 and 2, or are there any more defendants?
There's just two defendants is my
All right,
understanding.
so they both appear on my docket for a first-time pretrial. Mr. Mathis does not because, well, we put him at 8:31. So at some point, I was aware that Mr. Mathis needed counsel, or somebody was aware he needed counsel, so I don't know. But they're both basically at 8:30. Now my question is, based on your previous statement, Mr. Hill, the complaining witness that you said was with respect to Mr. Mathis, is that the same complaining witness for Ms. Reeder?
Yes, Your Honor, it's the same Elena Caldwell for both. And we did
Well,
have.
let me just say this. This becomes important to me. Now I do want to make a decision about something. I could keep the case because it's an even split. One party has a domestic relationship and one doesn't. But what is concerning to me is that I won't know if Mr. Mathis's case results in a conviction, and at sentencing, it would be important to me to know that there was a domestic relationship, because I would not order anger management. I would order that DV class. And so that makes me want to send it to Judge Garrett. But I could keep it because it's split, it's split. So Mr. Flanagan.
Yes, Your Honor.
Can you help me put it on the outside of the file, I guess by Mr. Mathis's name, a DV, and then put a note in the ROA that there's a domestic relationship. I'll keep it, but that's going to be important if the matter proceeds and I have to go to sentencing. I need to know that information at sentencing. That would be important. So as to both defense counsel's motion, I am going to deny the motions for dismissal. Give the people an opportunity to notify the witness of the obligation that she appears before the court. It sounds like she's trying to stay in touch as according to the people, she updated her address so that they would have her current address. So we'll give her an opportunity to give them an opportunity to notify her that she has to appear before the court. And I am going to adjourn the pretrial conference to Monday, September the 15th. Strike that. I'm going to adjourn it to Tuesday, September the 16th. At 8:36. The complaining this is for both cases. The complaining witness is required to appear. Failure of the witness to appear will most likely result in the matter being dismissed unless the people have a valid explanation as to why the witness did not appear or should not be required to do so. Bond is continued with no contact with the complaining witness. Anything on behalf of Ms. Reeder?
Nothing on behalf of Ms. Reeder, Your Honor.
On behalf of Mr. Mathis?
No, Your Honor.
Then we're all set. Everyone have a great day. Stay safe.
All right, thank you. Send me in.
You're welcome.
Your Honor, as a house.
Well, I'm sorry I didn't miss anything while I was out. I had to step out of the studio for a minute because it sounded like somebody was sawing through the side of the bunker here. But it turns out the next door neighbor is getting a tree removed from their front yard today. So that's what I was hearing. So yeah, let's go back to Miami-Dade, see how Judge Glazer's holding up.
Judge, Mr. Fountain is currently homeless.
All right. Give it for probable cause, your choice.
No, he'll accept tap.
Pardon me? Tap's
He'll accept
okay?
tap.
Okay. Tap alternate bond. $1,000. And so, sir, you have to come to court for your arraignment on October 3rd at 9 a.m., courtroom 3-2, Judge Block. Have a good day. Next is Willie Jackson, page 20. Mr. Jackson, good morning, sir. You were arrested for possession with intent to sell cocaine within 1,000 feet of a church or convenience store. I will appoint the public defender's office for you.
So it's U gas station, doesn't specifically say convenience store.
Nope. So there's probable cause for possession with intent to sell cocaine. They found 46 baggies of crack cocaine weighing 11.5 grams. So there's probable cause for possession with intent to sell cocaine. Your bond is $7,500. Have a nice day. Now I can start on page 1 with the ladies.
Judge, we have number 66 still here, Mr. Genty, Michelson Gent. Am I saying your last name right? Yeah. He's on page 21.
Let's see. My papers go from 20, I'm sorry. It goes from 20, what is his name? It goes from page 20 to 22. I don't see a page 21.
Starts with leaving the scene of a crash with death.
Oh, it's over here, maybe. I got it, thank you. Mickelson Jency, page 21. Good morning, sir. So you were arrested for leaving the scene of a crash causing a death, which is a first-degree felony, and tampering with physical evidence. This is a case from August 25th of 2025. Sir, can you afford to hire a private attorney?
No, ma'am.
All right, I will appoint the public defender's office for you. Let me review. There's probable cause for the charges.
So
I
the
don't know.
defendant's got a prior federal conviction for wire fraud, 35 months, followed by 3 years of supervised release. And it looks like he successfully completed his term.
Okay, what do you want in terms of a bond? He has no priors that I see other than that. It's a first-degree felony. It's $15,000 for count 1. I don't know what bond state's seeking is. He confessed to it as well after the police approached him.
5,000 on count 2.
15,000 count 1 and count 2 tampering with physical evidence will be $5,000. Good day, sir. Ashley Fraga is page 1. Want to line up the ladies? Hi, Miss Fraga. Is that Miss Fraga or no? Where's Miss Fraga?
Judge, Mr. Jeanty is asking if Your Honor would be able to lower the bond any on his case.
Not on that charge, I can't. I didn't raise it. It's a first degree felony, leaving the scene of a crash causing
Would you
death.
lower count 2 then, Judge?
State, the standard is 2,500.
Flood the scene.
Gonna have it back, okay. I'll leave it at $2,500 for count 2. So it's 15,000 count 1, 2,500 count 2.
All right, friends, while she quote unquote lines up the ladies, and maybe Ellie visits me, let's take a moment and discuss today's sponsor of the show, and that is Aura. You've heard me talk about Aura for several weeks now, and Ellie has a few things to say about Aura as well. But listen, the bottom line is, and we should know this because of all the court we watch, is our information in this modern age is all over the place out there on the interwebs, and if we're not careful with who has it and we're not vigilant about it, big problems can ensue. And that's where Aura comes in. They're a one-stop shop when it comes to protecting your identity and protecting your data online. But the problems are pervasive. I'd like to read to you a message that I got from Google a few days ago. And I do a lot of business with Google for advertising and stuff like that. And they said, we're writing to let you know about an event, nice way to put that happened and affected a limited set of data with one of Google's corporate Salesforce instances used to communicate with our ad customers. Our records indicate business contact information and related notes were impacted. It says this threat was described in the Google Threat Intelligence Group blog post. The threat actor had unauthorized access to the Salesforce instance. The affected systems contained business contact information such as business name, phone number, and related notes so that a Google sales agent can do business with you. So not even Google themselves was able to stop my data from getting leaked, and then it gets into the hands of data brokers and bad actors, gets on the dark web, all of that kind of stuff, and then the next thing you know, you have a problem. But that's where Aura comes in, because they are constantly monitoring for you where your personal information is. They're getting it removed in all the places that they can. At the very least, they're making you aware of where it is. And their services go beyond that as well. They have transaction monitoring to make sure that your financials stay safe. They have spam and junk removal. They have an antivirus, a very good VPN, one I've actually used for years now. Parental controls, credit monitoring, you name it, they've got it. And you need it right now. It's the bottom line. And for the pennies really that Aura will cost you, the benefits are just crazy insane. But the good news is that you don't have to just take the risk. You can try it out. Just hop right on up there, Ellie. That'd be fine. Aura gives you 14 days for free, and during that time, you'll find out whether or not they can help you, and I guarantee that they can, because within 24 hours, you're going to find where all of your information is online and what they can do to help, and they'll start removing it for you right away. Isn't that right, Ellie? Yes, you tell them. I will admit this is the first time I've ever done an ad read with a cat on my back, so there you go, Aura. Even Ellie thinks that people should try your product. Aura.com/TCF, 14 days for free. Give it a go. There is absolutely no reason not to. Protect yourself online. I do. You should too. Aura.com/TCF, 14 days for free. Let's go back to Judge.
39 Flamingo Way in Miami Beach, Florida. You are not allowed to go to that location, and you must stay away from that home. Do you understand?
Ma'am.
All right, I'm setting a bond. Count 1. You want $1 or you want release outright?
Release outright, Judge. Would you consider TAP?
No. Count 1 is
Currently
release
homeless.
outright.
She could use a place to stay. That's apparently
Well-
under the guise of what was happening, Judge, is that according to the arrest form, the co-defendant said he had a place for them to stay.
Count 1 is, you know what? I'm not providing TAP. She has priors. 2024 conviction for November 2024 petty theft, false name. It's release outright, count one, $500, count two. Next is Beverly Goodlow.
Or if you want to waive the issue, maybe pre-trial on Goodlow.
You have Miss Goodlow here? Hello, ma'am. You were arrested for possession of cocaine and possession of drug paraphernalia. I will appoint the public defender's office for you. I can either reset it for a probable cause hearing, or we can waive the issue. I'll give you the TAP program or pretrial if she has a place to stay.
Okay, one moment.
If there's anybody here for a case on Zoom, you need to type the name of the case you're here for. Can you
Si hay alguien en Zoom que quiere hablar, por favor, escriba el nombre del acusado en el chat, por favor.
Judge, she wants the pretrial now, please.
Okay, pretrial services alternate bond, count one is $1,000, count two is $500. Have a nice day. Next case, Casey Buckman.
So I think it's the co-defendant's child.
1 second. Good morning, ma'am. You were arrested for child abuse and possession of cannabis. I will appoint the public defender's office for you. One moment.
So they're in a car with a child and the car is filled with marijuana smoke.
Okay, there's probable cause for the child abuse and possession of cannabis. Ma'am, you are ordered to stay away from the alleged victim whose initials are JFF. No contact with the alleged victim either directly, indirectly, in person, in writing, by telephone, or through third parties. No contact with the victim through social media or other electronic means. And you must stay at least 500 feet away from the victim, victim's home, and school at all times. Do not engage in any criminal activity. Do not use or possess illegal drugs. Do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. And you must immediately surrender. Actually, if it's not her child, why am I doing this whole thing? It's just,
I wrote a non for you, Judge.
sorry, just stay away from the child and stay at least 500 feet away from the victims. You can tear that one, the other one up. Tear this one up. Stay away from his home, school. So, do you have to go to the hotel where they're staying to get any of your personal belongings, or no?
It's
I think-
all in the car.
All
that I
right,
was arrested from.
all right.
They're both arrested, Judge.
I'm setting a bond. Count one, the child abuse. What do you want? $1,000. Count two, possession of cannabis, ROR. Or five. I don't know what the state wants. Can I have the
Well,
eight form? I
cannabis
think I
amount.
gave it to you. What do you want, state? You want a bond on both? You want to split
wanna-
500 each? I mean,
Judge,
At
would
least
you
the bond on
consider-
count one, count two, Judge, it's up to you.
Would you consider an ROR, Judge?
no. $1,000 bond, count one, ROR, count two. Next, Ariana Frecanco. So I got that one. I'm trying to look here.
Pre-trial, I think is okay. She may not qualify for a PD.
Okay.
Need the Spanish interpreter, please.
Good morning, ma'am. You were arrested for strong arm robbery and criminal mischief.
Señora, la han arrestado, buenos días, le han arrestado por robo con mano armada y también entrando en propiedad.
Ma'am, can you afford to hire a private lawyer?
Delito contra propiedad. Señora, ¿usted puede contratar su propio abogado? ¿Sí o no?
No.
No.
Sí, no sé.
Do you
Well,
work?
yes, I don't know.
Do you work?
¿Usted trabaja?
Tengo mi compañía de postres, si puedo.
I have a dessert company. Tiene que hablar al micrófono que no te oigo.
How much do you make a week or a month?
¿Cuánto ganas a la semana?
300, 400, depend.
Okay. I'm appointing the public defender's office for you.
Bien, le voy a nombrar abogado de oficio para que la represente. ¿Está bien?
Gracias.
Ma'am, you
Thank
were
you.
ordered to stay away from Daniel Sanchez, the father of your child.
Señora, le han pedido que se aleje de Daniel Sánchez, que es el padre de su hija o hijo.
No contact with the victim either directly, indirectly, in person, in writing, by telephone, or through third parties.
No puede tener contacto con la víctima ni directamente o indirectamente en persona, por escrito, por teléfono o por tercera persona.
No contact with the victim through social media or other electronic means.
Tampoco puede tener contacto por medios sociales o otros dispositivos electrónicos.
And you must stay at least 500 feet away from the victim, his home and school and place of employment at all times.
Tiene que mantenerse a todo momento 500 pies de la víctima, casa, escuela, empleo y donde frecuente a todo momento 500 pies.
Do not engage in any criminal activity. Do not use or possess illegal drugs.
Señora, no puede tampoco participar en actividades delictivas, usar, consumir o poseer drogas ilegales o ilícitas.
Do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition.
Tampoco puede usar, comprar, poseer o portar pistola, arma de fuego ni munición.
You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court.
Tiene que entregar todas armas de fuego, munición, permiso de arma oculta y presentarla en la estación de policía más cercana y entregar recibo con los secretarios judiciales en el tribunal.
And, ma'am, do you live with the victim?
¿Usted vive con la víctima, sí o no?
No.
No.
All right. Do you understand the stay away order?
Señora, ¿entiende la orden de alejamiento?
Claro. Yo la
Yes,
quise
of
hacer.
course.
Yo la quise
¿Cómo?
hacer para él y la policía no me dejó.
¿Usted qué?
Yo quise hacer una orden de alejamiento contra él también y la
Yes.
policía no me dejó.
Yes, I wanted to do a restraining order also against him and the police did not allow me.
All right. Third-party contact is permitted for exchange of your child for time sharing.
Entonces, para el contacto de tercera personas es permitido solamente para el intercambio de las visitas para la otra, para el padre. ¿Está bien?
All right. Pretrial alternate bond. Pretrial services alternate bond.
Puede salir a través de un programa que se llama Pretrial o puede ahí no tienes que poner fianza monetaria.
Count one, strong arm robbery.
El
Is
primer cargo,
$5,000. Count two, criminal mischief is $150.
Ahora, el primer cargo, si quieres presentar fianza, son $5,000. Eso es robo con mano armada. La fianza es $5,000. Ahora, la segunda es el segundo cargo es delito contra propiedad, que son, how much was the second one, Judge?
$150.
$150. Thank you.
All right. Let me know if you see the Creole interpreter come in. I don't know.
I was just looking, they haven't even summoned them yet because they
Kara
probably.
Kellum, page 3.
Okay.
Kara Kellum there, it says it's reset for an arrest warrant in Ward D.
Coming up, yeah.
I don't know why they wrote reset for arrest warrant. Maybe no reset. I don't know. It just says reset. It's there's probable cause. Good morning, sir. Mr. Kellum, you have arrested for 2 cases. Trafficking in oxycodone from August 29th and another case driving as a habitual traffic offender. I will appoint the public defender's office for you. There's probable cause for driving with a revoked license. The bond on F25-18866 is $2,500. No drive order, sir. No driving unless you have a valid license. The other case, there's probable cause, I believe, for trafficking in oxycodone. He had 57 oxycodone pills weighing 34.2 grams. Say, what do you want for that? It's a first-degree felony. You want $15,000 bond?
Okay.
$15,000 bonds on this other case.
Judge, would you consider a reduced bond if
I
if
had
a-
went to.
That is reduced. I usually set those a lot higher.
Judge, in the arrest form, on page 2, it discusses that he removes his prescriptions label because his son is has a drug addiction issue, and that way his son doesn't know what his medications are. So, Judge, it appears that he has a prescription. He'll have to obviously get that from the pharmacy.
All right, I'll set count 1. What do you want me to set it at? 7,500?
I mean, the
Give him-
state's requesting the 15,000.
Does he have priors? Yeah,
Right, so the minimum mandatory, let's see.
enough for that.
Wait, it's gonna be the 7, no, I'm sorry, it's the 15-year min-man.
He doesn't have priors for that.
I don't
That
think
sounds
there'll
a-
be any drug priors in IC.
The driving is an issue though, Judge, so we got,
That's 2,500 there. This one I'll do 7,500. Okay. I'll take it. I'll give him a chance. He doesn't have priors for that. 7,500 for the trafficking in oxycodone. You're talking about 57 pills, although it's a highly how do you say addictive substance?
I don't know if that caused the crash. Or it was a factor.
You shouldn't be driving. And they only do prescriptions anyway up to 30 days. They don't do 57 pills. Miss Corey, they only do the prescriptions for 30 days for those narcotics, not 60 days.
Judge, Judge, I'm sorry, I didn't hear what you said.
I said those prescriptions are only given, they only do 30-day refills, 30 pills. They're not gonna be given 57 pills, so.
Judge, if it's 67 pills, then I would imagine you're being prescribed-
57.
No, it was 6.
That's 1 month. I'll leave his bond at 7,500. I'll give him the benefit of the doubt.
So, Judge, just because you're saying it's that amount doesn't mean it's not prescribed more than once a day.
Oxycodone?
Yes,
Yeah,
Judge. Depending on the dosage amount, it might be PRN. Who knows what it is? But until you have that, you can't assume what the prescription is.
Mhm. Next is Pedro Rosas.
Defense counsel is 100% correct there. Judge has no idea what she's talking about. And I know this is somebody who's taken care of my father and my mother and my wife's father. You can be prescribed more than 1 painkiller per day. And by the way, it's not necessarily just a 30-day script. For my wife's father, we would fill it in 90-day increments. So sorry, Judge, you're wrong. We'll come back to her. Let's stay in Florida, but let's go say good morning to Judge Anna Garcia.
And case number 25 CF 344. Mr. Anderson, good morning. All right, Mr. Anderson, your attorney, Ms. Simpson, is here with me. Please listen carefully.
Your Honor, Mr. Anderson's being arraigned today on 25-344 CF And at this time, on that information, we acknowledge receipt, waive formal reading, enter a plea of not guilty to those charges, Your
Let me
Honor.
ask, has an information in fact now been filed on that case?
Yes, Your Honor. it has.
Okay, fair enough.
And so we would schedule that for the October 21st date, that we'd schedule the other one for that date also. Your
All
Honor.
right, October 21. Is there a motion to reduce bond that's still pending, or has that already been
That's
heard?
still pending.
All right.
We'd like to have that.
Is
heard
the
at
state
this time.
ready to be heard on that issue?
We can proceed on the.
All right, Ms. Simpson?
Your Honor, the motion states that he's got bonds set in these cases. It's a total of $60,000. He financially is unable to pay that, and he has in his possession, or his family does, 1,500 that they could pay toward a bond, and he's presumed innocent. He also has some medical issues, Your Honor, that require treatment, and he has a hernia, and he needs to have a colonoscopy because of colon cancer possibly. And so we're asking for you to consider reducing his bond so that he could get out and get that medical treatment.
All right, state?
Your Honor, Mr. Anderson has an extensive criminal history. He has 6 prior felonies on his score sheet, including prior fleeing to elude and prior grand theft. He has 3 prior failures to appear, 1 in 1996, 1 in 2009, and 1 in 2019. The state's position is that the bond as set is reasonable given his extensive criminal history and his failures to appear.
It's 65 for all of the counts. 1, 2, 3, 4, 5 felony counts, and 1, 2, 3, 4, 5 misdemeanor. About. I might be off one or
You
two.
mean his current charges? There's 6 total charges on that the state has filed informations on, Your Honor.
But I also have him on a grand theft and a credit card theft.
Yeah, there's another case.
Oh, I'm sorry, the other
343.
case. I apologize.
Yeah.
I think that's correct, Your Honor.
So
I only had
8.
this one on the docket.
Okay. All right, anything further? Yes, sir.
I was locked up on those FTAs, Ms. Garcia. So, I mean, they hit me with FTA, but I couldn't get to them because I was incarcerated.
Sure. So the court's bigger concern, Ms. Simpson, is the fleeing, right?
Right.
And so to ask for bond reduction after fleeing, I may consider it, but 15,000 total for a $1,500 bond is just simply too low. Maybe something higher. The request is denied without prejudice. I will consider something that puts a little bit more skin in the game for everybody involved to make sure that he comes back to court. But at this time, Mr. Anderson, it is denied as requested for it to be reduced to the neighborhood of 15,000, okay? Now, as far as a continued court date, then October 21, right, guys?
Yes.
Yes, Your Honor.
Okay, so Mr. Anderson, I'll see you then at the latest at 9 a.m., okay? Thank you. Ms. Simpson?
I believe we also have out there a Jenna King on jail.
Give me 1 second. Let me get to that case number. Jenna King is here in case number 25 CF 252. Ms. King, the court is appointing the Office of the Public Defender to represent you. Ms. Simpson is here from that office on your behalf. Ms. Simpson?
Your Honor, she was first appeared this weekend, and at this time, she's here before you on this new case, and we would acknowledge receipt, waive formal reading, and her plea of not guilty, and ask you to set her case for November 13th. I'll go out to the jail and talk to her about her charges and everything.
What says the state?
No objection, Your Honor.
All right. Ms. King, I will see you at the latest then on November the 13th, okay?
Do I have to sit here till November 13th?
Yes, ma'am. Your bond has been revoked. Give me 1 second. Let me pull that up. I'm assuming it's new law charges, but let me find it. Hold on. Don't say anything though about your charges because that could hurt you, okay?
She has a,
Guys, I'm showing the warrant on 25 CF 252 not yet served. Ladies, is it possible that, because she came in over the weekend? Okay, yeah. So Ms. King, your bond has, I've revoked your bond because you allegedly committed the new law offense of DWLSR. So yes, ma'am, you don't get out of jail if you were out on bond, allegedly committed a new law offense after you're out on bond, then you sit in jail until your cases are resolved. Okay?
and I'll check with Calhoun County about that charge down there too, Miss King.
So even if I didn't know my license was suspended,
That might be a basis for a, so listen, here's the thing, Ms. King. Don't say anything, but if you were out for child abuse and DUI, your license gets suspended on a DUI. You're going to be hard pressed to convince me that you didn't know your license was suspended when you got the DWLSR after the DUI. But Ms. Simpson, I'm happy to hear argument if you think that there's a legal basis to make such an argument.
And I will go to the jail to talk to her. She
Fair
just
enough.
got appeared this week.
Fair enough. Yes. Yes, ma'am. So Ms. King, your attorney will be in contact, but usually people know that after you get a DUI, you lose your license for a minute. Okay.
okay.
All right. Thank you, Ms. King.
I've got one in Holmes County, but they are not, I don't think they've zoomed in yet because they have first appearance. That's Miss Lovett. So I've got
Fair enough.
Janice Johnson.
Whenever you see them, Elizabeth, we'll
Okay.
we'll take it. Okay. And Deb, if you see Holmes, let us know and then we'll get Elizabeth's case done. Miss Johnson, good morning. Ms. Johnson, we're here in two of your cases, case numbers 25 CF 348 and 25 CF 363. Ms. Johnson, the court's appointing the Office of the Public Defender to represent you, and Ms. Simpson is here from that office on your behalf, okay?
Your Honor, on behalf of Ms. Johnson, we acknowledge receipt of the information, waive formal reading, enter a plea of not guilty, schedule her to return on November the 13th. Your Honor.
What says the state?
No objection, Your Honor.
All right, Ms. Johnson, I will see you at the latest November the 13th at 9 a.m., okay? Thank you, ma'am.
And next I have Demetrius Ward.
Mr. Ward, good morning. Mr. Ward, we're here in your case number 25 CF 255. Ms. Simpson, the Office of the Public Defender is appointed to represent you. Ms. Simpson is here from that office on your behalf, okay? Listen carefully.
Your Honor, on behalf of Mr. Ward, at this time, we acknowledge receipt of the information, waive formal reading, enter a plea of not guilty, schedule him to return November the 13th.
What says the state?
No objection to the November court date, Your Honor.
All right, Mr. Ward, I will see you at the latest November 13th at 9 a.m., okay? Okay, see you then.
Marcus Johnson.
Madam Clerk, are there any out of custodies that I need to inquire that don't qualify per the indigency? Thank you. Thank you. Got it. All right, Mr. Johnson, good morning.
Good morning.
Mr. Johnson, we are here in your case number. Give me 1 second. Gee. Case number 25 CF 384. Mr. Johnson, do you wish for the court to appoint an attorney to represent you? Well, actually, hasn't information now been filed?
Yes, Your Honor.
All right. Do you wish for the court to appoint an attorney to represent you in this case?
Yes, ma'am.
All right. I'm going to appoint the Office of the Public Defender to represent you. Ms. Simpson is here from that office on your behalf. Okay. Listen carefully.
Yes, ma'am.
Your Honor, on behalf of Mr. Johnson, we would acknowledge receipt of the information, waive formal reading, enter a plea of not guilty, schedule him to return November the 13th at 1 o'clock in the afternoon.
What says the state?
No objection to the November date.
Mr. Johnson, we'll see you at 1 o'clock on November the 13th, okay?
Yes, ma'am.
Mr. Johnson, and for all of you criminal defendants out in the audience, please listen carefully to what I'm about to say. It is very important that if the Office of the Public Defender is appointed to represent you, that you keep in touch with your attorney, okay? I want Ms. Simpson to know your new phone number and address before you call your mom. Okay, that's how important it is that she knows how to reach you at all times. I don't want anyone to end up in jail because they weren't here and their attorney couldn't get up with them.
Yes,
Okay,
ma'am.
so keep in touch with Ms. Simpson and I'll see you November the 13th at 1 o'clock.
Yes,
Okay,
ma'am.
all right, thank you, sir. Ms. Simpson, do you have anybody else?
Yes, I do. I have Tashana Johnson.
Tashana LaSharon Johnson is coming up in case number 25 CF 247.
Dylan White, you can come and stand at the bar and be ready.
Ms. Johnson, good morning.
Good morning.
Ms. Johnson, do you wish for the court to appoint an attorney to represent you?
Yes, ma'am.
I'm going to appoint the Office of the Public Defender. Ms. Simpson is here from that office on your behalf, okay?
Your Honor, on behalf of Ms. Johnson, we acknowledge receipt of the information, waive formal reading, enter a plea of not guilty, and schedule her to return on November the 13th at 1 o'clock.
Okay, Ms. Johnson, keep in touch with Ms. Simpson, and I'll see you November 13th at 1 o'clock, okay? All right, see you then.
Thank you.
Mr. White, come on up, sir. Mr. White is, give me 1 second. Mr. Dylan Jermaine White is coming up in case number 25 CF 76. Mr. White, do you wish for the court to appoint an attorney to represent you? Yes? Okay, I'm going to appoint the Office of the Public Defender. Ms. Simpson is here from that office on your behalf, okay? Please listen carefully.
Your Honor, on behalf of Mr. White, we acknowledge receipt of the information, waive formal reading, enter a plea of not guilty, schedule him to return September the 16th.
What says the state? All right, Mr. White, we will see you. Do you think you're going to have a conflict?
Yes.
Okay.
I mean, not a conflict. We think we have
A resolution.
He's sick today. He needs to go.
Oh, sure, fair enough. Mr. White, we will see you September the 16th at 1 o'clock. Between now and then, keep in touch with Ms. Simpson, okay?
Norris Wynn.
He stepped out.
Okay, and that may be,
Oh, okay.
I think that he may,
Oh,
doesn't he have a high ball? Yes, that is. Gonna hire his own attorney, Your Honor. I think his bond is rather high. I didn't know if they were gonna drug test him or not.
but we wanted to. No, 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 I don't have, yeah. Yeah, no, EMS is with him. So we'll call him in a little bit.
Okay, I'll wait. That's
Well,
fine.
you don't,
And
but if you also want to have him signed, then that's fine.
he's signed to come back, Your Honor.
Fine, so he can go if EMS is treating him then.
Okay, well, you want me to announce it for the record?
Yeah, if you don't mind.
Your Honor, I spoke with Norris Kelvin Wynn in case 25-300. And on those charges, we acknowledge receipt of the information, waive formal reading, enter a plea of not guilty. I scheduled him to come back November 13th. Your Honor, he did post a high bond, and I told him that he may be questioned about that bond. He informed me he might be hiring his own attorney. And I haven't.
If he comes back up. If not, we'll talk to him next time. I don't see Holmes County on there yet, but I do see Mr. Ramey. Mr. Ramey, if you're on the line, if you'll come on, give me just 2 seconds. I've got 2 people I need to ask about. Mr. Ramey, good morning.
Good morning, Your Honor.
Mr.
Judge,
Ramey, what do you have?
I was here earlier, Judge. I had to pop in to see Judge Bufano in Liberty County, so sorry I'm a little tardy with you. I have
You're fine.
State versus Alexandra Goss, 23-385, except for Raymond.
All right, 25 CF 385. Is that an out of custody?
Yes, ma'am.
All right, excellent. And did you, has an information been filed state?
Let's see if I can pull it.
I've got alleged child abuse.
Goss.
Mr. Ramey, I believe that was the case that I said I was going to call up because I wanted to understand if the state intended to file charges or what the plan was.
The state has not filed an information yet. We have, let's see where we're at.
we've reached out to GAC for some additional information. We're just waiting back for that.
Do you want to set on the next private attorney date?
That's fine, Your Honor.
Mr. Amy, are you already here on October the 7th?
Give me half a second. Look.
Sure. October 7 at 1:30 is my next private attorney day. I think that still gets us within the, is it 63 days or 60? What is it?
We
Okay.
got,
Does anyone know?
it
Derek, do you?
should be,
What's
I
the
think the
whole
case
first
came in-
appearance, filing in information within 60, 63? Do you know any of that?
I was on the email.
I think the
chain, but I
case
don't
came
know
in
about-
August 20th, so if we,
October should be fine.
yeah.
Mr. Amy, you good
October
for October 7th?
Yes, ma'am, I'll be with you.
All right, at 1:30. We'll set GOSS
ma'am.
for October 7th, ladies, pretrial at 1:30. We'll see if the information is filed. If not, then we'll move forward. All right, Mr.
Thank you,
Amy, does
Honor.
that take care of all your cases?
It does, Your Honor. Thank you. Great to see you.
Excellent. Thank you. Good to see you too. Mr. Craner, you're on. What are you doing? What you got?
Case number 25 CF 167 in Carolyn Renee Ostrom, OSTRUM.
Give me 1 second.
Yes, ma'am.
I think, Mr. Craner, we have you for this afternoon at 1:30.
Okay, that's fine.
Let me
I'll
make
come-
sure. Hold on, let me make sure.
Thank you, ma'am.
Yep, it's at 1:30.
Okay, I'll come back then. Thank you. Appreciate you.
Thank you so much. Okay. All right, Mr. Blunt. Holmes County's still not on. Deb, any updates from Holmes County?
No, ma'am.
Yeah, no updates from Holmes County yet. Yes, sir. Oh.
So let's rotate back to Judge West for a minute. But I got to tell you, I get, as part of watching these court proceedings and all the different feeds, I'm constantly fed other things as well that, for various reasons, I guess YouTube and the other platforms think I'll like. And one of the most bizarre things I've just seen, there is a 24/7 feed for episodes of Knight Rider. They just play them back to back. But what's interesting is there are 2,000 people watching that right now. There are 2,000 people watching David Hasselhoff in a talking car. The internet is amazing. Anyways, let's get over to Judge West. Whoop. Let's not get over to Judge West. Things just reset with her. Not sure what happened there. Let's continue with Judge Garcia while I figure that out.
Did you already announce a date?
Yes, it will be November 13th at the latest.
Okay, perfect. Thank you.
Thank you.
All right, does that take care of all your cases, Ms. Simpson?
Yes, it does.
Okay. All right, Mr. Blunt, help me.
Yes.
What are we doing?
We're gonna try to go down the list and call the out of custody cases. If your name's called, please come up. Do not leave this courtroom until you speak with an attorney, but we're gonna go ahead and arraign you and tell you which attorney you have if there's an information filed in your case. But do not leave until you speak with the attorney that is appointed to you. Your Honor, after that.
Okay, I got it reset. Back to Judge West.
Announcement.
The defense is ready, Your Honor.
And on behalf of Mr. Coleman, it's ready as well, Your Honor.
All right, Mr. Pamias, I want to make sure you understand that after today, I will not accept any plea agreements. So I want to make sure you still want to reject the state's offer and go to trial.
They don't give me anything good.
Well, the offer was 25 years on one case, dismissing the two other cases, and 25 years if you go to trial and are found guilty is the minimum punishment.
vas a tener que pagar 25 años en cárcel, ese es el mínimo.
Because of your prior felony convictions.
Porque las otras fenómenos que has tenido en el pasado.
There was also an offer after that
Y también hubo otro oferta después de eso.
where the state offered to waive the habitual offender status
Y el Estado estaba dispuesto a renunciar al estado de
and allow you to plead open to the court to a second degree felony, which means that you would leave your punishment up to me and I could sentence you anywhere in the range between 2 and up to 20 years in prison. So do you want to reject that and go to trial? Or take that offer?
I cannot give up my innocence.
Okay, then we'll go to trial next week. I'll number the cases after docket.
Yes, ma'am.
Thank you, Ms. Cepeda. I didn't get on Andrew Jackson a pre-sentence report, did I? What's the agreement? Is there something that you can print out for me, please, or pull up? Or send it back to me or something so I know, please.
I'm sorry, I reprinted it because it didn't have a date on it.
That's okay. Mr. Kemmler, you've got Rebecca Rito. Okay, thank you. You can just, okay, yeah, the sticky's fine, whichever. Good morning, you're Rebecca Rideau. And this is 25 DCCR 0336. Ms. Rideau is charged with tampering or fabricating physical evidence with intent to impair. And what is the announcement?
Your Honor, what do you want to take it off?
Y'all go talk about this somewhere else other than in front of
The
me.
last time I spoke with her, she didn't want to.
Okay.
I want to make sure.
Okay, go have a seat in the jury box. Y'all talk about it before you get in front of me. She's in the back. You can go visit with her before you stand in front of me. Mr. Kemmler, on Gabriel Smith.
We talked to you.
This is a recent to reconsider.
Yeah, that's what she wants to do.
Go talk to her in the back before you come up here. Well, then just ask me to hold them for a minute. I'll hold them. Go visit with them. You were just sitting in the jury box. I figured you were ready. Mr. Burbank, on Devin Byerly?
Can we approach before you bring them out, Judge?
Sure. Morning.
Good morning, Your Honor. There was something in the PSR report or the updated that the state needs to check out. We have an agreement.
We do have an agreement, Your Honor, if the court will accept it for Mr. Byerly to go to safety and also enter a plea on the misdemeanor case. This is, and I don't need to publicize it, but that underline is what I need to check. and make sure the status of that with respect to the new offense, whether we dismiss or do something concurrent. I have spoken with Ms. Johnson about going to safety. I understand probably the court's hesitation based on his update, but
Yeah.
that was our thoughts.
Okay, well, let me just,
Reconsider
2
if
weeks,
we
you,
can. Sure.
okay, let's reset it for 2 weeks. You can check on the status of that and then, we'll see from there. Okay, thanks.
Thank you.
And then, Andrew Jackson sentencing, Mr. Burbank. Andrew Jackson. And the, y'all already did the registration
I did the last
way back time, I think. Yeah, I think so. Let me double.
Do I need to put an updated one?
Because they did, when they did the plea before, I feel like we would have.
I did.
I'm sorry. So, and do it for sure. I guess let's do this in the 0045. Yeah, please. Yeah, if y'all will get that done real quick, and then I'll take care of it as soon as that's done, Mr. Burbank. And then, sure.
You have to take them out back statement. Okay, that's all right. Cool.
Yeah, on Andrew Jackson, sure.
Okay, well, if you want to bring them in now, I can.
You can. He's going to do that, and then I'll take care of it in just a minute.
Okay.
Whenever they're ready. Mr. Lewis, you have Zabaris Harrison.
Yes, ma'am, Judge.
Good morning.
Good morning, Judge.
Good. There's no paperwork on this one.
No, he's gonna plead to the motion and
Okay.
do the updated PSI.
Good morning. Are you, is it Zabaris? Zabaris Harrison?
Yes, ma'am.
And Mr. Lewis, will your client waive the formal reading of the motion?
He does, Judge.
And Mr. Harrison, the best you can, would you raise your right hand, please? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you, sir. And will he waive the formal reading of the motion?
He does.
And Judge, with the court's permission, we would move to abandon what should be numbered 4 with respect to the fees. It looks like there's some typographical errors on that.
Oh, okay. Thank you, ma'am.
And just move on 1, 2, 3.
Okay. I have a motion to revoke your unadjudicated probation, and this is 23 DCCR 1410. It shows that you were placed on probation July 22nd of 2024 for the offense of assault family violence with previous convictions, and that was a 4-year deferred probation. Is that correct? This motion alleges that you violated your probation. Count 1 alleges that you failed to report as directed February 11th, March 11th, and April 24th of 2025. And is that true or not true? Count 2 alleges that you failed to provide verification of performing the community service as ordered. Is that true or not true? Count 3 alleges that you failed to provide verification of entering and successfully completing the BIP program, the Battering Intervention and Prevention Program. Is that true or not true? Did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily? And did you plead true to those because you actually did what they allege? All right, then I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. I'm going to reset your case so the probation department can do an updated report. That'll give me more information about you and what's been going on with your case, and then we'll come back later for sentencing. Anything that you think is important for me to know, get that information to Mr. Lewis. He'll present it to me on your behalf when we come back. Okay? We'll see you back at sentencing. Unagreed.
So it's a weird world. In the pre-show we tried, tech didn't really work for us, but we attempted to cover a story where a woman in Pennsylvania drove through a crowd and ran a couple people over. And, it was weird because it was a woman. Currently in LA, there is a standoff on a highway where they've stopped a woman in some kind of an SUV. There's like a dozen police cars around her, but apparently from the reports I'm seeing, she's in the car naked. So, the world's losing its mind. Anyways, we're a court channel, so let's do court stuff. Let's go to Judge Middleton. He's doing sentencing.
Regarding Joseph Tanner Richards. Both matters are set for sentencing here today. Defendant is here with his lawyer, Mr. Timothy George. Angelique Camfield is here from the prosecuting attorney's office, and Autumn Kiefer drew this tough assignment on preparing the screening reports. Autumn and I did have a chance to discuss this, and frankly, this is a tough case. He has had a CARS assessment, but has not had his formal assessment. Mr. George worked some magic and got the prosecutor to take 2 impaired driving pleas to this. The first incident was a 219. The second incident was, I believe, 9.097. Mr. George, we'll start with you and see if we can figure out how we should proceed here.
Well, thank you, Your Honor. I think in a lot of ways, Autumn may say it a different way, but I think she gets to the point that is kind of at the core of Mr. Richards. The first time that we came on the very first case, I know he was upset, frustrated, as many clients are when they're here on their first court appearance in an OWI case. But after the second one happened, I think that he realized that there were some things that were going on that weren't healthy for him. Autumn does indicate in her report, and it's consistent with what he's told me, that the lifestyle that he was living was one of these get out of work and drink at night and drink on the weekends, and which isn't uncommon for kids his age, but it was clearly putting himself in situations where he was putting himself at risk by getting behind the wheel of a car and putting the community at risk. Now, fortunately, both of these circumstances, ended up with no injury to himself or anybody in the public. But, the first one was very scary where he was passed out behind the wheel. And then the second one was a little bit more innocuous, but he was still over the legal limit. And I think that talking to Mr. Richards, he realizes that he was running probably a lot harder than he thought he was at that time. And I think that, he has 2 young kids. He has the benefit of having the children's mother still in his life, and she's going to help to get him around if the court were to put him in a sobriety court.
Did I know that he had 2 kids?
But I think he wants to help. He's still very young, so I think he's still learning. And I think that some education, some treatment, and seeing others that are in a similar situation and maybe have had their lives go astray because they didn't have intervention at an early age would be beneficial for him. And I know it sounds coarse, but as Autumn says in her report, the worst that could happen would be a failure. But I think that in talking with Joseph and going over everything that Autumn's asking him to do, he's coming in with the right attitude. I know we need to get that assessment done. He's got that scheduled for next Monday. I think he'd be a good candidate for your program, Your Honor. And we'd ask the court to adopt the recommendation as we believe that it's appropriate. Thank you.
This is interesting plea agreement. And we can go, we have flexibility on what to do, but the question is, what do we do? Ms. Campfield, what's your thought here?
Your Honor, I know I spoke with Ms. Kiefer just prior to going on to the record, and she indicated due to not having the assessment, it may be appropriate to adjourn one or more of the sentencings today until we have that back. However, given the frequency with which these are occurring and the closeness in which they occurred, I would like him under supervision as soon as possible. So my thought process is to perhaps sentence him on 25-145 SD and perhaps postpone the 25-951 SD for that assessment to see if we can go into the sobriety court under that one pursuant to the assessment. What concerns me also is the high blood alcohol on the January offense with a 0.219. He indicated in that he had been over to his family's home to a dinner, that he had fallen asleep and got up to go to work, was trying to be responsible, and then pulled over and passed out with the vehicle running because he was feeling ill. I'm not surprised he was feeling ill at a 0.219, even after presumably having slept some of that off. I do want to note, although I have no proof of it, he had a 2019 reckless driving where he drove off the road into someone's porch. And I'm concerned that the reason he left and did not report that.
He had 2 of those.
Yes, was because he was drinking at that time as well. Again, I have no proof of it, but given the pattern of conduct here, I suspect it has been going on for a much longer time than he was willing to relay to Ms. Kiefer. So at this point, I do agree with the recommendations. I think it's appropriate for him to be in sobriety court. I'm very concerned about the path he's on. I do think there's an alcohol dependency, and it's getting worse. Having said that, the one thing I might recommend modifying, because there are 2 of these in a matter of months, would be perhaps a little bit additional upfront jail before beginning sobriety court, if that's the court's idea, to place him there as an incentive not to go back.
Mr. Richards, usually I go with Ms. Kiefer next, but I want to hear from you. What would you like me to know?
What was that?
What would you like me to know?
This past year, it's just been stressful, and I had a house out in Cass. My grandpa passed away, so I had to move back in with my brother in St. Joe County. So I was moving and trying to work and had a lot going on.
Where do your kids live?
They live with me.
Which is where now?
240 West 2nd Street in Constantine.
All right. And how old are they?
My son will be 4 on the 12th of September, and my daughter just turned 2 in June.
Tell me about your job.
So I was working at Coach or Dutchman, and then they dropped down to 3 days a week, so the money wasn't there for me. So I went back to my old job doing construction, and I found a new job in a trailer factory at Coachman. And I got orientation tomorrow for coachman.
Well, I'm strongly considering putting you in jail right now, immediate, which might affect your orientation tomorrow. The January incident, you were very drunk, and despite what you say, you were in the middle of the intersection at 131 and Riverside Drive, which is a terrible place to be passed out. And you're apparently going to work at almost 3 times the legal limit for alcohol. You don't pay your fines and costs. You owe me hundreds of dollars in other tickets. 6. No insurance, no proof of insurance. They cut you a break and let you plead to no proof of insurance. You haven't paid the fine. Sent notice, mail undeliverable. That was in front of Judge Pattison, 22940. Operating without a valid license. Pled to allowing another to violate the motor vehicle code, $325 or 3 days jail. I don't believe you ever made a payment. No insurance under the insurance code again. Admit to no proof of insurance in 2023. You didn't pay that either. Let's keep going. Violation of seatbelt law 2022. You didn't pay that. 8. No proof of insurance again, January of 23. So you got 3 no insurance, reduced to no proof of insurance, and you never paid any of the fines. Defective equipment, 2024. You never answered the ticket. Didn't pay that either. Then you had a couple things that were attached to this. What's this? You got a ticket for impeding traffic since this incident in May. What's that? You got a ticket for going 79 and a 55 on July 14th. What's the status of that? And they wrote you impeding traffic, which is a huge break. $907,071. I don't see it in here. Have you answered that ticket that you got in July?
No, I haven't. I haven't gotten any. I just got my address switched over and everything. Me and another car, a car passed.
Don't tell me more about it. Autumn, in light of the additional information we just discussed, he's got a new hyper speeding ticket. He's got 7 unpaid current tickets, including 3 no insurances, which he kept getting a break from no insurance to no proof of insurance. Didn't pay the ticket. Got a break from no operator's license to allowing another violate the motor vehicle code. Didn't pay the ticket. He is very immature. doesn't quite get it. And you said that when we were discussing it, but he really doesn't get it. He might get it after about 90 days in jail. I have a glimmer of insight. We've been considering sobriety court for several weeks since the second incident in May. What's your thought here?
Well, it's imperative that he gets this assessment because we all know that that is self-reported. And the fear would be is that he not fully self-report and be truthful with that assessor. And you can't not be in treatment if you are in a treatment program. I asked him flat out if he thought he had an alcohol problem, and he said no, which is concerning, but wanted to blame everything else in his life that had been happening for the reason for his drinking, and that's truly not the case. He is young. He has 2 young children. He needs to figure this out. He has an awful driving record to be so young. I'm going to leave it up to the court, but I would be fearful of the fact that if we sentence him into a sobriety court program today and we get an assessment back that states that he doesn't need treatment, then what are we going to do with him?
It's a hard thing to realize when you're 24 that you have a substance abuse problem and that you can't drink, because one thing, it's fun, what everybody else is doing. I tend to agree with Ms. Camfield. I think 1 or more of those reckless driving incidents was alcohol related. You're only 24. You got all these other tickets, which you've promptly ignored. They cut you a break 3 times. You paid them back by you and your horse. Then you get a speeding ticket going 80 miles an hour while you're on these 2 bonds, which I don't know what the status of it is. It probably said appear within 14 days to the court, and you haven't done that. In the first incident, and I often disagree with the alcohol assessors. I don't need a degree to determine that someone who's at 1217 in the middle of an intersection at 7 o'clock in the morning. This would have been a Saturday morning. January 25th was a Saturday. So I don't think you were going to work. A citizen actually called it in. White pickup truck at the intersection appears to be passed out. They tried to honk the horn. They couldn't tell whether they're breathing or not. Police officers get there. Subject parked in the driving lane. Parked in the intersection, running with the driver sleeping, passed out behind the wheel at 6:37 in the morning. January 25th would have been a Friday into a Saturday morning, so I don't know if you're going to work. Then they had to block you off before you took off because you were so out of it. The truck was actually in drive. At least you had 2 car seats in the car, but no kids in it. You needed to be home with your wife and kids, not out drunk in the middle of an intersection on a Saturday morning. A 24-pack of Budweiser on the driver's side floorboard and an open bottle of beer leaking out the driver's side onto the roadway. This is just a sad story. And then it gets worse. But you were cooperative with the police. All right, I tend to agree with Ms. Kiefer. We need the assessment on the other case. I suppose if I put him on probation, I can make him pay all his fines and costs, or I can just give you a bunch of jail. You'll get out about Christmas time, and I can wipe out some of those fines and costs. But we're going to try this. 25145 SD. Impaired driving. Wrong judgment. At some point, there becomes a consequence. Blowing off all these tickets, not paying any fine, not answering my letters regarding payment, getting arrested for drunk driving, while on bond for drunk driving, getting arrested for another drunk driving, while on bond for 2 drunk drivings, getting a ticket for going 80 in a 55 and not responding to the ticket. At some point, it finally all catches up. In that case, I'm going to order 4 days jail, credit 2, leaving 2 days to serve. You got a family. I'm just going to give you the minimum fine in that of $125. You're going to pay that or do it 2 additional days. When did you have your last drink of alcohol?
I think right before the last time I had court in here.
I'm going to continue this sentence. Did you even know you had all those unpaid tickets? Yeah, they're just off your radar. You get a ticket, they give you a break, they reduce it. We send you a letter, you don't pay, they give you a break. You got 3 of those, 3 no insurance reduced to no proof of insurance. A driving suspended or no ops reduced to allowing another to violate the motor vehicle code, and you just, then you get a speeding ticket, same thing. It'll go away. Maybe it won't. Let's continue the sentence. For substance abuse assessment. In 25951 ST. That's the case if you do sobriety court that I'm going to do the probation in. You're gonna lose your driver's license because you're gonna have 2 drunk driving convictions within a 7-year period. So if it hasn't already hit, it's about to hit. This first one will restrict your license. When the second one hits, it'll be suspended. It'll actually be revoked for 5 years. Unless you go into a sobriety court program, in which case we can get you an interlock after 45 days. I'm not sure you're ready for it. And we also have this speeding ticket out there, which could also affect your ability to get your license straightened out. Let's find a date that works for Mr. George to put that second case. Those things that I found here are just in St. Joe County. I don't know what else you got in Cass County. If you got unpaid tickets over there as well. Tim, I was looking for a day that maybe you would be here. I've got Jordan Harden on Monday, the 29th. Can you do that of September?
Yes.
We'll set that for 11. I have 3 sentences at 11. All right, here's the deal. I've continued the second case, the May case, for your ability to get your assessment. You're gonna have to be honest with those people. If you're going to say, I don't have a problem, they're gonna say, well, he doesn't have a problem, so he's not eligible for sobriety court, which means you'll be eligible for a big bunch of jail and a revoked driver's license. We're gonna figure out what the deal is with all these unpaid tickets, find out what the status of your speeding ticket from July is. But you're going to jail right now for 2 days. You're gonna miss orientation tomorrow. I told you eventually it caught up with you. Well, it just did. You keep blowing stuff off and pretending like it didn't happen. Well, it just happened. So I gave you 4 days jail, credit 2, leaving 2 days to serve. I waived 0 fine, 0 screening fee, 0 attorney fee. Take it all out of the other case. This is money that your family needs. And then you got to pay me $125, which is the minimum fine, or you're going to do 2 additional days in jail. But you got 2 days to think about what you want to do, whether you want to go to jail and lose your license, or whether you want to try to successfully do a probation and start to acknowledge your responsibilities. So you go to the officer. I will see you on September 29th at 11. You're at the West 2nd Street address in Constantine. And I want you to be honest with the alcohol assessment people. You're good to go.
All right, since he's finished with that contestant, let's go back to Miami-Dade because Glazer is now working into lunchtime. So let's see how this is working out.
Judge, he was in custody from November 13th, 2024 to May 5th, 2025.
Well, he still has an obligation to report, I guess, if he's not in custody.
It wouldn't be 18 counts.
November to May.
November 13th, 2024 to May 5th.
And there was no house arrest, he was out?
Well, he's supposed to report on the 22nd, so it'll be 6 months, so that's fine. Counts 1 through 12. Let me see. So it's 6 months that, count 1 through 12 is $2,500 each count. And count 13 through 18, you want $1 each on those or ROR?
ROR, please.
ROR each count. Next is Sedan Stirrup. Or Sedan Stirrup. Page 10. Ooh. Not even halfway through the calendar yet. Good morning, Mr. Stirrup, sir. You were arrested for robbery by sudden snatching and I'll wait till he's away. Good morning, sir. Or good afternoon. You were arrested for robbery by sudden snatching and battery. I will appoint the public defender's office for you.
Got no priors.
All right, so he snatched the phone. You're ordered to stay away from Mari Castillo, the alleged victim. No contact with the victim either directly, indirectly, in person, in writing, by telephone, or through third parties. No contact with the victim through social media or other electronic means, and you must stay at least 500 feet away from the victim, her home, school, and place of employment at all times. Do not engage in any criminal activity. Do not use or possess illegal drugs. And do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court. And you may return to the victim's residence one time only within 48 hours of your release from jail. You must be accompanied by a police officer so that you can retrieve your personal clothing, health items, medication, personal and business-related paperwork and work tools. If you go to the victim's home without the police, or if you stay there, you will be arrested. Do you understand the stay away order, sir? He also should have been charged with false imprisonment. He wouldn't let her leave. There's probable cause for the charges. You have somewhere else you can stay? That's not with the victim?
She does not live there, Judge. That's his mom's house. She doesn't live there.
All right. Stay, what do you want me to do?
I mean, he also, it's a little violent and then he slammed her to the floor.
You want house arrest?
That's fine.
House arrest with a GPS monitor. Alternate bond, count 1, robbery by sudden snatching is $2,500. Count 2, battery is $1,000. Level 3 house arrest with a curfew from 11 p.m. to 6 a.m. with a stay away order from the victim. Have a good day, sir. Next we have is Philip Frazier. Page 10. Good morning, sir. You were arrested for possession of a firearm, gun, weapon, or ammunition by a convicted felon in child abuse. I will appoint the public defender's office for you.
We saw the co-defendant. I think it's actually his child.
Right.
They're not local.
He's a convicted felon. It's child neglect. Or actually, it would be child abuse, I think.
They don't state they don't state the type of crime that he was convicted for.
They don't have, they say he's a convicted felon, right?
Well, it says that he was convicted of criminal possession, weapon, 2 loaded firearms. They don't state he's a convicted felon.
It does say, I'm looking at his priors, it does say it's a felony.
Sir, I'm gonna order that you stay away from the minor child whose initials are JFF. No contact with that child. Either directly, indirectly, in person, in writing, by telephone, or through third parties. No contact with the victim through social media or other electronic means. And you must stay at least 500 feet away from the victim, his home and school or daycare at all times. Do not engage in any criminal activity. Do not use or possess illegal drugs. And do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and follow receipt with the court. Yeah, sorry. You may return to the victim's residence in the event there's an open case in dependency court arising from the same set of facts and events as this case, then any and all orders entered in dependency court regarding your contact, visitation, and custody shall supersede or replace this court's order. So do you understand the stay away order?
Yes, Your Honor.
All right. Now, one is.
So Judge, without indicating what the kind of crime that is.
There's probable cause. She just
He was
told me.
sentenced- Right, he was sentenced to 4 years in prison, followed by 3 years of release.
Count one is $7,500. Count two, the child abuse will be $1,000. Good luck to you, sir. Next case we have is Hector Perez Colon, page 10.
Just to give you guys an update, we're going to ride with Judge Glazer for a while. There's court's real spotty today, which I kind of expected because some judges will extend their weekends. But there's itchy trigger fingers out there today. Judge Garcia, who we were monitoring, Judge West, and a couple of others have immediately deleted their feeds once their docket went to recess. So not a metric ton to show you, but Judge Glazer's always entertaining, so we're just going to stay here for a while.
Smoking in the car.
Let me see the arrest affidavit, David, again. I thought he was standing outside the car drinking, leaving his child. Okay, so it would be child neglect. Yeah, count two should be child neglect. Still $1,000. Next is Hector Perez Colon.
Spanish interpreter, please.
Buenos días, señor.
Sir, good morning. Good afternoon. You were arrested for
Buenas tardes, mejor dicho.
failure to obtain proof or identity of an employee.
So I think he refusing to give the
Let me translate. Falta por esto dar identificación de un empleado. Go ahead.
So I think it was for refusing to provide the officer with his driver's
license.
Sí, es que no le dio al oficial la licencia, identificación.
So it's failure to provide a driver's license.
Entonces es falta de no dar una licencia de conducir. la identificación,
which is sort of the same as resisting without.
que es más o menos lo mismo resistiendo sin violencia.
Count 2 is assault on a law enforcement officer, and count 3 is resisting an officer without violence.
Entonces, el segundo cargo es agresión por las autoridades, hacia las autoridades, y el otro es resistiendo de un oficial sin violencia. Son tres cargos.
Corrections. I'm sorry. Sir, how long have you lived in Miami?
¿Y cuánto tiempo vive en Miami, señor? ¿Cuánto tiempo? Hable al micrófono.
For a couple
You speak
years.
English?
He speaks some English, but
Yeah.
you
I would like to talk with
Do
the,
you want a Spanish interpreter or not?
no, no.
Okay, he doesn't need a
Okay,
Spanish.
all right then.
Yes, sir. There's probable cause for count 1's the same as resisting. I can split 1 and 2. What's the assault on a law enforcement officer?
He attempted to hit him. It says, then move forward with his black and gray belt in his hands towards the officer in an attempt to hit him.
Is it a
They
resisting
didn't
with
say he
violence?
attempted to hit him.
Yeah, they did.
They're saying that he moved forward with the belt in his hand as in the attempt, but they're not saying he was doing it. Looks like they were concerned about it.
No, they were trying to hit him. There's probable cause for the charges. Count 1, $250. Count 2, assault on a law enforcement officer, it's $1,000. Count 3, resisting without is $500. That's $250. Have a good day. Next is Freddie Salcedo Mejia.
It's a dwelling, no amount of damage. Actually, no, there is an amount of damage. I apologize.
Spanish, please.
Good afternoon, sir. You were arrested for burglary to an unoccupied conveyance with prejudice, but it's actually a dwelling and criminal mischief. Is the interpreter here, Jackie?
Yes, I'm sorry. I was still translating. Le han puesto cargo por robo de vivienda o estructura no habitable.
And count 2 is criminal mischief over $1,000.
Y el segundo cargo es delito contra propiedad, pero era más de $1,000
I will appoint the public defender's office for you.
de daños. Así que le voy a nombrar un abogado de oficio para que les represente.
Sir, you are ordered to stay away from Rebecca Rosales, the alleged victim.
Señor, le han pedido que se aleje de Rebeca Rosales, que es la supuesta víctima. ¿Está bien?
No contact with the victim either directly, indirectly, in person, in writing, by telephone, or through third parties.
No puede tener contacto con la víctima en persona, por teléfono, texto, a través de terceras personas.
No contact with the victim through social media or other electronic means.
Tampoco puede tener contacto con la víctima por medios sociales o dispositivos electrónicos.
And you must stay at least 500 feet away from the victim, her home and school and place of employment at all times.
Y tiene que mantenerse al menos de 500 pies de la víctima, su casa, escuela, empleo y donde frecuente a todo momento.
And stay away from the victim's residence at 550 Northwest 30th Street in Miami, Florida.
También tiene que alejarse de la dirección de la víctima, que es 550 Northwest 30 Calle en Miami, Florida.
I'm setting a bond. There's probable cause for count 1 burglary to an 1 second.
Entonces le estoy fijando la fianza. Hay motivo fundado para el cargo de hurto o robo.
And count 1 burglary to an unoccupied dwelling is $7,500. Count 2 criminal mischief, $2,500.
Entonces, el primer cargo es $7,500 y el segundo cargo es $2,500, que es el delito contra propiedad. ¿Está bien?
I don't see a value for count 2.
On the
No veo
bottom,
el
it lists
valor.
the damages on the bottom. MacBook, Chromebook,
Oh, there it is. I see it.
Xbox,
Ahí ya lo
smart
encontré.
television.
I got
Sí,
it.
televisión, Chromebook, como tipo
Have a good
computadora.
day. Stay
Ya
away
puede
from the
tomar
victim.
asiento.
So I looked something up. If you caught it at the beginning of that hearing, she read off the charge as burglary with prejudice. So I was curious exactly what the difference was there. So I looked up Florida law. Florida statute 775.085, commonly known as evidencing prejudice while committing an offense. And basically it says the statute is structured to elevate the severity of penalties for certain offenses when they are committed with a demonstrable element of prejudice against a particular group of individuals. This legal framework effectively recognizes that crimes driven by bias or prejudice not only affect the immediate victims, but have a broader impact on the targeted community and society as a whole. So I was curious, and I don't know if we'd be able to follow this case, but what exactly happened with that burglary, and why is it so special that they would feel that it has a broader impact on the community at large? That's a curiosity of mine. And I don't know what it would be, but that's why it was charged with prejudice, apparently. So there's more to that story, bottom line. Back to Judge.
Your Honor, the interpreter is going to be replaced. Juan Maurin is going to
Thank
be.
you.
Okay, so
Thank
just
you.
look out for him.
So why
Thank
is it armed? For the pressure washer
No,
gun?
no, no, the other case.
Oh. No, I don't, yeah, that one. Okay. Sorry, good afternoon, sir. So it's an armed burglary on F-25-19007. Sir, you are ordered to stay away from Guy Dure, the alleged victim, no contact with the victim either directly, indirectly, in person, in writing, by telephone, or through third parties, and stay at least 500 feet away from his home, school, and place of employment at all times. So on this case, F-25-19707, it's no bond. And the other, you're gonna have to
It's
see a
not
judge.
clear if they're talking about the pressure washer.
No, it says right here, the subject stole his duffel bag with his gun and clothes from his vehicle.
Judge, but when they discuss it on the other arrest form, they're talking
There's
about
a pressure washer gun
a
from the
pressure
yard,
washer gun.
just from the yard.
That's not in the duffel bag, a pressure washer. It's too big. The other case, which happened later, the pressure washer gun was taken from his yard. There's probable cause for burglary to a structure on this case. Looks like a dwelling, isn't it?
I'm not sure.
All right. I'll find burglary to a structure. On this other case, it's a $2,500 bond for F-25-19006. Have a good day.
Let's change it up a little bit. Let's go to Fulton County, Georgia. This is Judge Melanie Williams. They probably had a party this weekend. Let's see what kind of mischief they were up to.
We're going to give him credit for 14 days from February 7th, 2025 to February 8th, 2025, and then August 22nd, 2025 until today. Balance probated, no further contact with Lashunte Teague. Stay away from the 7 Courts Apartments that's located at 2800 Martin Luther King Jr. Drive Southwest, and FVIP, as well as no firearms. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea, and we would like to sound for Lashunte Teague. On position number 2, we are entering a null pros at the conclusion of the plea on position 1.
Thank you. Mr. White, that was your understanding of the agreement, and do you so stipulate?
That's correct, Judge. We do stipulate, and that is our understanding.
All right, and is Ms. Teagues present and wishes to make a statement? All right, hearing none. Mr. Anderson, please raise your right hand. Do you swear or affirm, Mr. Anderson, please raise your right hand. Thank you. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge and is given under the penalty of perjury?
You swear to tell the truth?
Yeah.
Do you want to take a plea today, Mr. Anderson?
No.
I'm sorry, but you can put your hand down. Speak loudly. Do you want to take a plea?
Yes.
And you sure that's what you wish to do today?
Are you sure?
Yes.
Doesn't seem like he wants to take this plea, Mr. White. Is he sure that he wants to do this? Before we go through all the questions and that's not what he wants? Do you want to go to trial or do you want to please take a plea today, sir?
Yes, I take the plea.
Okay. And that's what you want to do, correct?
Yeah.
We're gonna go through the questions and see. If I feel satisfied, we'll go forward and take the plea. If not, we may reset this case, Mr. White. All right. He's under oath. Are you under the influence of any drugs or alcohol at this time?
No.
Did anyone force you to take a plea today?
No.
Did anyone promise you anything in exchange for taking a plea?
No.
Are you satisfied with Mr. White's representation? Mr. Anderson,
That's okay.
are you satisfied with your attorney's representation?
Yeah.
And you understand the requirements? If you take a plea today, you're giving up your right to trial by judge or by jury? Please mute that screen, whoever that is, Mr. Jordan. Thank you. You understand you're giving up your right to trial by judge or jury? Okay, we're not gonna take this plea today, Mr. Wright. I don't think Mr. Anderson really wants to do this. He's not responding in a timely manner. Do you wish to reset 1 week SAP?
Judge, if we could just hold off on that, we can move on to somebody else and I'll speak with him and make sure this, he's, once you said that, he said he was adamant that he did say yes, so I don't know if you want to.
Okay, you want to keep forward. Let's see. You understand you're giving up your right to trial by judge and jury, Mr. Anderson?
Yes.
And you understand you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Yes.
And you understand you can't have any contact with Ms. Teagues. You'll need to stay away from that location. You're gonna have to take a family violence course that's about 6 months. And you're gonna actually have absolutely no firearms. You understand all of that, Mr. Anderson? Is that a yes?
Yes.
All right, thank you. As to the charge of simple battery family violence, how do you plead? How do you plead, Mr. Anderson?
Yes.
All right, I accept your guilty plea. You should not have additional time to serve on this case in the Fulton County Jail, but you will have some requirements upon release. Best of luck to you, Mr. Anderson. That concludes your case for today. Who do we have next? Who do we have next?
Position number 5, Butler, Robert Butler.
It's also a negotiated plea, Judge.
Thank you. Mr. Butler, your case is 25 CR 004666E. In this case, you're charged with making terroristic threats. Do you understand your rights today?
Yes, ma'am.
Thank you for that. Ms. Falk?
Yes, Your Honor. On Mr. Butler's case, the state's recommendation is going to be 12 months with 44 days to serve, credit for time served 22 days. That will be from August 12th, 2025 until today. Balance probated, 12 weeks of anger management, a social worker visit, no further contact with Bradley Fry, and stay away from 2574 North Clark Drive in East Point. We would like to sound for Mr. Bradley Fry, and we do ask the defense to stipulate to venue factual basis and identification for the purposes of the plea. That's all for the state.
All right, Mr. White, do you so stipulate?
You can stipulate, Your Honor.
All right, thank you. And is Mr. Fry present, wishes to make a brief statement? Hearing none, Mr. Butler, please raise your right hand. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge and is given under the penalty of perjury? Thank you. You can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No,
Okay. Did anyone force you to take a plea today?
no, ma'am.
Did anyone promise you anything in exchange for taking a plea today?
No, ma'am.
And you understand if by taking a guilty plea, you're giving up your right to have state prove these charges against you beyond a reasonable doubt? And you understand that you'll have no further trials about this. This is the end of that case today by taking a plea. And you fully understand the requirements that you're going to take anger management for 12 weeks. You're not going to have any contact with Mr. Fry. You're going to stay away from the location in East Point, but you should not have additional time to serve on this particular case. Do you understand all of that? All right. As to the charge of terroristic threats or acts, how do you plead, Mr. Butler? I accept your guilty plea. Is there anything additional from the state or from the defense?
Nothing, Your Honor.
All right. Best of luck to you, sir. That concludes your case.
We can do, position number 14 over at Oconee, Mr. Marquise Jones.
And who represents Mr. Jones?
I'm sorry, which one?
14.
Number 14.
That's mine, Judge.
Sir.
And the announcement for that is?
I'm sorry, Judge, that's going to be a plea. He was reset from last week.
Okay. Okay, Mr. Jones, your case is 25 CR 002199A. You're charged with battery, family violence, 2 counts of cruelty to children in the third, and criminal trespass. Do you understand your rights this morning? Is that a yes?
Yes.
All right, thank you. Ms. Falk?
And Your Honor, this is position 14, Marquise Jones, correct?
Correct.
The state's recommendation on this case is going to be 12 months served 30 days, credit for time served 2 days from April 27th to April 28th of 2025, balance probated, FVIP, no further violent contact with Kirissa Jones. Count 2, 3, and 4 will be 12 months concurrent with count 1. We did have an opportunity to speak with Ms. Jones. She stated she agrees with the plea and would like to have contact with the defendant, which is why the contact is no further violent contact. She stated they are no longer living together and she has left the residence. And she also stated they are currently separated. We would like to sound for her. She was unsure if she was going to be joining today, but I would like to sound for Ms. Jones at this time. And we do ask the defense to stipulate to venue factual basis and identification for the purposes of the plea. That's all for the state.
Ms. Falk or Mr. White, how many additional days will he have to serve?
He should, it's 13 days, Judge, but he has already been had a probation violation.
Right. His probation was revoked on his felony matter. Is that correct?
Yes, that's correct.
Okay.
Okay, understood. All right. Is Ms. Jones present and wishes to make a statement? All right, Mr. Jones, please raise your right hand. Do you swear or affirm that the testimony, Mr. Jones, please raise your right hand. Do you swear or affirm the testimony you give today will be the truth to the best of your knowledge and is given under the penalty of perjury?
Yes.
All right, thank you. You can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No, ma'am, but I would like to talk to my public defender.
Okay, so is there a phone number he can call from the Oconee jail?
Yes, Judge, it's 404.
Or is there somebody there that can help him make that call?
Yes. I believe so. I talked to him last.
Okay, yeah, go ahead, Mr. White.
And PD White, I'm going to put something in the courtroom 2 chat just in case.
Okay. 404-612-2060-2060.
Okay, so can we take a position that doesn't belong to Mr. White for a moment while he makes that call?
Ms. Tucker is busy.
I'm available.
Okay, well, let me turn your camera on then.
Well, there hadn't been a case called.
All right, can we take a position that belongs to Ms. Tucker?
Go to ACDC.
We're muted at ACDC. Thank
Yes,
you.
Judge. Yes, Judge. I have position number 15 and 16, McCullough, Tammy.
And Ms. Tucker, what's the announcement for those?
That'd be my case, Judge.
Mr. Haddad?
Negotiate plea.
All right, thank you. All right, good morning, Ms. Tammy. Your case is 22 CR 004002Y. In that case, you're charged with theft by taking, and you also have a failure to appear case. Do you understand your right?
Yes, ma'am. Yes, Your
All
Honor.
right, thank you, and I appreciate you speaking loudly. Ms. Falk?
Yes, Your Honor. On the theft by taking, position 15, state's recommendation is 12 months to serve 28 days. Credit for time served 14 days from June 22nd to June 23rd of 2025, August 22nd, 2025 until today. Balance probated. Stay away from Nordstrom Rack, located at 6200 North Point Parkway in Alpharetta, an anti-theft course, and 40 hours of community service. On position 16, the state will enter a null pros upon the acceptance of the plea on position 15. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea. That's all for the state.
All right, do you still stipulate, Mr. Haddad?
I do, Judge. I would just ask the court to consider perhaps terminating or non-report upon completion of the conditions, Judge.
State has no objection to non-reporting.
All right, she can go non-reporting once she's completed the requirements, all right? Ms. McCullough, please raise your right hand. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge and is given under the penalty of perjury? Thank you. You can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No, Your Honor.
Did anyone force you to take a plea today?
No, Your Honor.
Did anyone promise you anything in exchange for taking the plea?
No, Your Honor.
And you understand that taking the plea, you're giving up your right to trial by judge or jury?
Yes, Your Honor.
And you understand you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Yes, Your Honor.
And you understand the requirements fully, including that you cannot return to Nordstrom Rack. You're going to take an anti-theft course, and you're also going to complete 40 hours of community service, but you should not be serving additional time on this particular case. Do you understand that, Ms. McCullough?
Yes, Your Honor.
As to the charge of theft by taking, how do you plead?
Guilty.
I accept your guilty plea. And again, she can go non-reporting once she's completed the requirements. Best of luck to you, Ms. McCullough. Take care.
Thank you. To you as well.
All right. What do we have next?
Judge, we can make an announcement on Mr. Jones at Coney County. He's just going to enter a not guilty plea, and I'll just file a waiver this morning.
All right, understood. So your attorney has some additional development to do in your case, Mr. Jones. Your case will be reset for the notice, all right? Take care. All right. Coney County can be excused. Who do we have next?
Number 6, Bird.
And the announcement, my announcement email still didn't come through. Oh, I got
sent
it now.
to your Fulton County email address.
I got it now. Thank you, Ms. Falk. All right. I have that this is a negotiated plea. Is that correct?
That's correct, Judge.
Thank you, Mr. Bird. Your case is 25 CR 004847B. In this case, you are charged with criminal trespass. You understand your rights today? Is that a yes? All right. I do need you to speak as loudly as you can so that we can understand you. All right, Ms. Falk?
Yeah. Yes, Your Honor. State's recommendation on the criminal trespass is 12 months, serve 34 days, credit for time served 17 days from August 17th, 2025 until today. Balance suspended. Stay away from the Georgia Institute of Technology property in its entirety. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of this plea. That's all for the state.
And you so stipulate, Mr. White?
We do, Your Honor.
All right. And that was your understanding, correct?
That's correct, Judge.
All right. Mr. Bird, please raise your right hand. Do you swear or affirm the testimony you give today will be the truth to the best of your knowledge and is given under the penalty of perjury?
I do.
All right. Thank you. And I appreciate you speaking very loudly. Are you under the influence of any drugs or alcohol at this time? Did anyone force you to take a plea today?
No.
Did anyone promise you anything in exchange for taking a plea?
No.
And you understand that taking a plea, you're giving up your right to trial by judge or by jury.
Yes, Your Honor.
And you're giving up your right to have the state prove these charges against you beyond a reasonable doubt.
Right, Your Honor.
And you understand the requirements that you should not have additional time to serve on these charges. However, you cannot return to Georgia Tech in its entirety. Do you understand that, Mr. Byrd?
Correct, Your Honor.
All right. As to the charge of criminal trespass, Mr. Byrd, how do you plead?
Yes.
I accept your guilty plea. Don't go back to Georgia Tech. They don't want you there. Is there anything additional from the state or from the defense?
Nothing additional, Your Honor.
All right. Best of luck to you, Mr. Byrd. That concludes your case.
Thank you, Your Honor. Thank you, Judge.
All right. Who do we have next?
Next, Judge, I have position number 10, Ms. Shirley Esther.
And that's Ms. McLeod. That's your case?
Good morning, Your Honor. That is my case.
All right. Thank you. All right. Ms. Esther, your case is 24 CR 001225Y. In this case, you're charged with simple battery and simple battery against a correction officer. Do you understand your rights today? I can't hear you at ACDC. I'm assuming that's a yes.
Your Honor, my client has some severe limitations. I did email the state to explain what was going on with Miss Esther.
Right. I did receive the email this morning that you sent. I'm trying to ascertain. It wasn't really clear how she ended up back in custody. So
they went to her home and arrested her. They just went to her house and arrested her.
Right. I heard the words they went to her home and arrested her, but people don't normally just randomly get arrested on cases from 2024.
Well, before we do that, what is the announcement for
or
this
something
case?
happened?
What are we doing with this case this morning?
With this case, Your Honor, I'm trying to get my very sick client out of jail. That is what I'm trying to
I understand. So she's not taking a plea today.
Your Honor, I just wanted to bring to the court's attention what is going on. Miss Esther was injured and had some brain damage. She had a case, this case that she's in jail for was before Judge Edie recently. I was in contact with her family who provided me some information indicating that she had some brain damage. I spoke with the prosecutor in Judge Edie's courtroom, brought it to the attention of the judge, and it was agreed that there would be a 60-day reset so I could get some more detailed medical records on Miss Hester. To my surprise, shortly thereafter, her sister informed me that they came to the house, said they had a warrant for her arrest for this case because it doesn't show that there's any other thing in the system for her, and took her to jail. That is where we are at. I'm just trying to get my client out because she is not well right now and should really not be in jail. That's the bottom line. I don't know what the state's position is, but I did share with Ms. Falk what had been going on between myself and the prosecutor in Judge Edie's courtroom regarding my client.
Okay.
If I may, Your Honor.
Go ahead.
Okay. So I received the email this morning. I actually have figured out what's going on. I just took a look at her jail record. Contrary to what Ms. McLeod has stated, she's actually in jail on a cruelty to child warrant under 25 PI 006813 with a $10,000 surety bond. As Your Honor, I'm sure knows, that is not a misdemeanor case, that's a felony case. And so she has to bond out on that case. She also has a probation violation hold under 23 SC 187723. That has no bond. She will not be going anywhere on that case, and that's a felony as well. The only cases that she is in jail on for us are the simple battery and the simple battery against a law enforcement officer, which is pretrial, came off her bond once she was arrested.
Yeah, those other cases.
Yeah.
Okay.
So that's why she's in custody. We can set whatever bond Your Honor feels comfortable with, but she is not getting out of jail today.
Right. Okay. Understood.
Well,
all right.
I have to advocate for my very sick client. I don't care what the allegations against her may be. It does not alter the fact that she's very sick.
We understand that, but what Ms. McLeod, I think the point here is that she's not, this case even if we did something here today, the other cases would still have her sitting here.
I
Yes,
understand,
sir.
Your Honor, and I do not,
So,
unfortunately, represent her in the other cases. But I'm of the opinion when people are as sick as my client is, that they should not be in jail. This is supposed to be a civilized society. You do not put people who are that sick in jail. You find some alternative method of addressing things, especially when these are just allegations and nothing has been proven against them. And even if things are proven against them and they're that sick, you should find a facility for them to go to, not just have them stuck in jail. That's my opinion.
well, Ms. McLeod, you have my vote. Okay,
Yeah,
but today there's just
and I think that is definitely something she should take up with the
There's not a
DA's
lot we-
office, who currently has her in custody.
Okay, so what do you want to do today as it pertains to these cases, Ms. McLeod? Do you want to waive arraignment or do you want to discuss
I've already
bond?
done all of that, Your Honor. I have been on top of this case from it was before Judge Edie. I know exactly who my client is. I've been in touch with
Understood.
the family constantly. And all of that has already been done, like the waiver of arraignment, everything.
Okay, so I guess the best thing to do is to set this case back to the division. And you can continue to work with Judge E. She does have a bond, even though pretrial took it back, there's still a bond. It became a
Yes,
surety.
it is a
So she does have,
$2,000.
she has a
Yeah.
bond at this
She has a
point.
$2,000 surety bond on each case. We're even, Your Honor, we'll even agree to reset her back to pretrial services if Your Honor is fine with that.
I'm not gonna do that. Once pretrial has come off it, I'm not gonna send it back to pretrial. Okay, so we're gonna we're gonna send this case to the division, reset for the notice, all right? And I do appreciate your advocacy and your position, Ms. McLeod. You make a lot of great points. There's just not a lot that we can do in light of the circumstances for Miss Esther today.
Thank
All
you,
right.
Your Honor.
All right, so reset to the division.
Thank you, Your Honor. I do have another client at ACDC who will be taking a negotiated plea this morning.
All right, can we take Ms. McLeod's other case?
It's Miss Smith. She has, I think, 3 positions.
She does. Good morning, Ms. Smith. Your case is 20. You have several cases. The first one, 20 CR 003834Y. These are driving offenses: driving with license suspended, reckless driving, DUI, driving on a divided highway, and driving without a license. In 21 CR 008020Y, you're charged with theft by receiving, and again, driving without a license. And then 25, I'm sorry, the last one is what? Oh, this is an FTA. Do you understand your rights this morning, Ms. Smith? Is that a yes? Speak very loudly for me.
Yes, ma'am.
Thank you so much. It's not you. It's sometimes the computer does not pick up the sound that great. So just lean forward and speak loudly when we ask for you, all right? It's a negotiated plea, so we'll go to you, Ms. Falk. You're muted, Ms. Falk, if you're speaking to us.
Which position is this, Your Honor? I'm sorry, I had to send someone.
23, 24, and 25.
That's okay. I just want to make sure I was in the right place. On position 20.
I'm sorry, also Judge 26 as well. 23.
Oh, she has 26 as well. I'm sorry, Ms. Smith. You also have an FTA on that DUI. So she has 4 positions. Go ahead, Ms. Falk.
Thank you, Your Honor. On position number 23, which is going to be the driving while license suspended, 12 months, concurrent with count 3, which is your DUI less safe, and $1,000 fine. This is her second suspended license in 5 years. On count 2, the reckless driving, it will merge with count 3, the DUI. Count 3 will be 12 months, served 22 days, credit for time served 11 days from August 23rd, 2025 until today. Balance probated, ADET, DUI risk reduction, a victim impact panel, a $300 fine, and 40 hours of community service. Count 4, which is the divided highway road violation, will merge with count 3. Count 5, the driving without a valid license, as her license is suspended, we are entering a null pros on that count. On position 24, the theft by receiving stolen property will be 12 months to run concurrent with position 23. And on count 2, 12 months to run concurrent with count 1. On position number 25 and 26, those are the FTAs. We will be entering null pros at the conclusion of this plea. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of this plea. That's all for the state.
We do so stipulate.
All right, thank you, Ms. McLeod. All right, Ms. Smith, please raise your right hand. Do you swear or affirm the testimony you give today will be the truth to the best of your knowledge and is given under the penalty of perjury? Is that a yes?
Yes.
All right, thank you. Put your hand down. Are you under, you can put your hand down, ma'am. Thank you. Are you under the influence of any drugs or alcohol at this time?
No, I've been incarcerated.
All right. Do you fully understand the proceedings this morning?
Yes, ma'am.
Are you satisfied with Ms. McLeod's representation?
Yes, ma'am.
Did anyone force you to take a plea today?
No, ma'am.
Did anyone promise you anything in exchange for taking one?
Of course not.
I'm sorry? Did anyone promise
No,
you anything?
ma'am.
Okay. And you understand
No,
you're
ma'am.
giving up your right to trial by judge or jury? Is that a yes?
I said yes, ma'am.
Okay, thank you. And you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Yes, ma'am.
And do you fully understand the requirements as explained to you by your attorney, including the fines and the courses you have to take? You understand? You have $1,000 fine and a $300 fine and a anti-theft course. You're gonna undergo some evaluation. You're gonna do a victim impact panel and do a risk reduction course. Do you understand all the requirements of taking the plea today?
Yes, ma'am.
As to the charges I previously listed to you, Ms. Smith, how do you plead?
Guilty.
I accept your guilty plea. Is there anything additional from the state or from the defense?
Nothing, Your Honor.
Nothing further, Your Honor.
All right. Best of luck to you, Ms. Smith. That concludes your cases for today. All right.
Thank you, Your Honor. And that concludes my business before the court today. May I be excused?
Yes, you may. Take care, Ms. McLeod, and best of luck to your client as well.
Thank you.
And that concludes our business for the day with the court as well. I hope you all had fun. Interesting day. Courts were a little weird, though. I don't know why, but a whole bunch of them right at the very end of their dockets just deleted them, which courts that don't normally delete. So that was a little odd, but such is life. We still make a show out of it, after all. Speaking of shows, we'll be back tonight, 8 p.m. Eastern, 5 p.m. Pacific for Sidebar. So be sure to join me and Michael and Ashley and Superstar. And I think we might have a topic. Bailey and Ashley, I put it in our group chat, so take a look at that. Michael already has. But we'll see you then, and we'll be back here for the morning show tomorrow, 10 a.m. Eastern, 7 a.m. Pacific, a half an hour early for channel members. So hope to see you all back here tomorrow. And do be sure to check out our sponsor, Aura, aura.com/TCF. Seriously, give them a look. If you haven't yet, if you're on the fence, whatever, it's 2 weeks for free, nothing to lose. And I can tell you personally, it is making a huge difference in the amount of my data that is online. The amount of spam calls I'm getting, is really a big deal for me. It's dropped to like 0 now, so it's worthwhile. Aura.com/TCF. But we'll see you tonight, and we'll see you tomorrow. In the meantime, go have yourselves a great Tuesday. Take care. God bless.